morning. Thank you so much. Welcome back. All right, thank you so much. Have our witness return to the stand. Thank you. All right, welcome back. Thank you. Continuing with examination.
And Dr. Elcon, you do understand you're still under oath, correct?
Yes.
Okay. So when we left off yesterday, I was asking you about the jail medical records that you used as part of a basis for your opinion. Do you remember that?
That's correct.
And we had already talked a little bit about the intake form that the jail nurse completed from the night of February 16th. I wanted to ask you briefly about the intake form from the jail nurse on the night of, or I guess it was the early morning of March 8th.
Yes.
Do you remember noting in the intake form whether or not Ms. Mericle was asked if she had attempted suicide?
I do not.
You don't remember if it asked her that?
Correct.
If I showed you a copy of the intake form, would that potentially help refresh your recollection?
That would be great. Thank you.
Sure. So it's highlighted for you.
Yes. Thank you.
So does the jail intake form include a question, have you ever tried to commit suicide?
Yes.
And did she deny that she had ever tried to commit suicide?
She did to the jail nurse.
To the jail nurse, correct, in the intake form.
That's correct.
But to you, she said that she had a thought of committing suicide or wanting to commit suicide, correct?
That's correct.
But she didn't detail for you any actions or steps that she actually took to commit suicide.
She didn't.
Okay.
And I would add, it's not uncommon for individuals who are meeting, and particularly in that setting, to deny ever having thoughts of suicide, especially if they have interfaced with mental health in the past, because usually saying something like that will get you into a medical housing that you may not have wanted to go into.
Well, how about to you, the person who's performing a psychological evaluation for her murder trial? Is there a reason why she wouldn't have told you about her attempts to commit suicide?
Sure. I think that what she was telling me was past history. If you'll note, in the behavioral observations section of my report, one of the things that I routinely ask is about current thoughts of suicide, which she denied at the time of the evaluation.
But when she told you, when she was talking to you about the late night, early morning of March 7th to March 8th, did she ever mention to you that she had attempted suicide during that incident with Mr. Barron?
Yes.
And so I thought you said that she did not describe attempting suicide.
Yes, that she said that she had thoughts of suicide. I'm sorry, I misunderstood your question.
No, you're fine. It might have been a confusing question. So if you could explain exactly what you remember telling you about her thoughts of suicide, specifically as it relates to the incident with Mr. Barron where he was killed.
Sure. So after the incident where at the time she wasn't sure if he was dead, but it was right after the incident, she said to me in describing her recollection of that night, she said, "I was so distraught I thought about taking my own life."
Okay. Did you ask her any follow-up questions like, well, tell me what you mean by that? You know, did you have a plan? That's a common question, right, for a psychologist if someone brings up suicide, to ask them if they've actually taken steps to follow through with that plan, correct?
That's correct.
Did you ask her any of those questions?
Well, she said that she had the gun in her hand and she thought about taking her own life.
So did you ask her any follow-up questions? Did you put the gun to your head or to your body?
I did not.
Did you ask her if, did you try and pull the trigger?
No.
And then again, her telling you that she had thoughts of committing suicide after murdering her boyfriend was not something you felt important to put in your report?
I didn't put it in my report.
Because I guess that wasn't important to you as part of your evaluation?
I honestly think I thought about it last night. It was probably just a mistake.
Okay. So I know that you reviewed the other records and summaries in the jail medical records, and you would agree with me that Ms. Mericle repeatedly talks about her depression and anxiety as it relates to being incarcerated, correct?
Yes.
Do you remember reading a note, for example, that the client expressed feelings of isolation exacerbated by the confines of the correctional facility and struggles with low self-esteem? She's also reported difficulty sleeping and experiencing frequent negative thoughts, especially regarding future. The client mentioned feeling trapped and unable to escape her current environment, which contributed to her depressive symptoms. Do you remember notes about similar to that one?
Yes.
Do you remember notes similar to expressing challenges with emotional regulation, particularly in response to the stress and frustration of her current incarceration? She reported frequent feelings of anger, sadness, which she feels are often triggered by her interactions with other inmates and staff, as well as her limited control over her environment, and that she described several incidents over the past week in which she became overwhelmed and had difficulty managing her emotions, resulting in heated arguments and sense of losing control.
Yes.
And you would agree that all of those symptoms are essentially symptoms that you observed as part of your evaluation for PTSD, correct?
My evaluation, I would say more broadly, my evaluation for mental health conditions in general.
And part of what you used to help with your diagnosis of PTSD were those feelings of extreme depression, the emotional regulation, the nightmares, difficulty sleeping, things like that. Those were all things that you helped in your determination of a diagnosis of PTSD, correct?
Well, what I think you're trying to get me to say is that couldn't it just be that everything that she's reporting has to do with her adjustment to jail? I think that's what you're trying to ask me. Isn't it possible that the symptoms she's reporting have to do with struggling to adjust to an incarcerated setting? And to that I would respond, well, sure. And in fact, I acknowledge that. So on page 19 of my report, you'll see a diagnosis of adjustment disorder. That accounts for those symptoms that I observed from the jail records. Additionally, I would note on page 14 of my report, one of the things Ms. Mericle told me is that on advice of her counsel, she wasn't allowed or was advised not to talk about anything that happened prior to her coming to jail. So the only things that she was reporting to the jail counselor had to do with her immediate circumstances.
And you never met Ms. Mericle prior to her being arrested for these murder charges, correct?
That's correct.
And you never got any prior mental health records from Ms. Mericle, correct?
That's correct.
And you never spoke with any of the 6 of her therapists that she told you about, correct?
That's correct. And I would add here also, the one that would have been relevant, this evaluation, above all else, was really to account for the time of her relationship with Mr. Barron. In that time, she was kind of seeing a therapist who I tried to reach out to, couldn't get a hold of her, but she really wasn't attending therapy regularly while she was with Mr. Barron.
Right, and what about all of the other therapists that she was seeing prior to Mr. Barron?
That's correct. No, I did not get those records.
And isn't it possible that there might have been trauma or symptoms of PTSD from Ms. Mericle's past that maybe she talked with those other therapists that you never attempted to reach out to?
That's correct.
And what your test is for, as far as malingering, is malingering as to the symptoms she's exhibiting that are consistent with PTSD, correct?
Malingering for mental health conditions in general.
Right, so like faking symptoms or faking mental health, signs of a mental health issue, correct?
That's correct.
And then once you have determined that this person is exhibiting these symptoms or signs of a mental health issue, that's when you go and you talk with that individual about what could be the cause of those symptoms, correct?
That's correct.
And so when you spoke with Ms. Mericle and you asked her, what was that main trauma that, you would attribute to being the main factor in these symptoms, and she attributed that to Mr. Barron pointing the gun to her mouth on the late night, early morning of March 7-8, right?
That's correct.
So essentially, all of that aspect of your evaluation is self-report, correct?
That's correct.
And you have to assume that Ms. Mericle is telling the truth, that that event even occurred, to assume that that event is the basis for all of these PTSD symptoms that you exhibited, correct?
Yes.
And when we're talking about PTSD, the word post is in it, right? So like prior trauma that you've experienced that is now creating these current symptoms, correct?
That's correct.
And so the main symptom or the main event that the defendant describes as being the cause of all of these traumas is actually the night of the murder, correct?
That's correct.
So not post-trauma, but the current trauma that she's in jail for is what she says is the main cause of the symptoms that she's currently exhibiting to you, correct?
I'm not exactly sure of your argument because I evaluated her in September. The incident happened in March. That's 6 months post this incident. So at the time I saw her, she was exhibiting post-traumatic symptoms.
And so what I'm talking about is, there's been suggestion that Ms. Mericle's actions could have been on the night of March 7, early morning, March 8, could have been attributed to the PTSD that she had acquired from Mr. Barron, correct?
Yes.
But that event was currently happening in that moment, because we're talking about her experiencing PTSD symptoms on the night of the murder. I understand that you met her after the murder. I'm talking about what she was exhibiting the day of the murder as far as PTSD. According to Ms. Mericle, she had not even experienced that most triggering trauma yet. She was actively experiencing it, correct?
So as I testified yesterday, this was not the first traumatic event she had experienced in the course of her relationship with Mr. Barron. This was a chronic situation with chronic intimate partner violence. What I'm talking about is that that was the index trauma, so the most traumatic thing. I've also testified yesterday that she was experiencing nightmares, sleep problems, and generally heightened anxiety starting as early as October of 2024.
And that's all self-report, correct?
That's correct.
So you're assuming that she's telling the truth about what she was experiencing in October of 2024, correct?
Correct.
And because you don't have any mental health records prior to her relationship with Mr. Barron, you have no way to compare whether or not these symptoms are new and attributed to Mr. Barron, or whether she could have been experiencing certain symptoms from anything that happened in the first 61 years of her life, correct?
That's correct.
You say in your report that the defendant is consistent in her assertions of abuse by Mr. Barron, correct?
Yes.
But you would agree that nowhere in the case file, other than the night of, or the early morning of March 8th, is there ever any mention of past trauma between the defendant and Mr. Barron, correct?
Well, why would she tell?
And that's not what I asked. What I asked was, you would agree that there's no mention of past abuse between the defendant and Mr. Barron anywhere in the case file that you saw, correct?
She never disclosed it prior to that night.
Okay. So you would also agree that as far as sexual abuse, that's not disclosed by the defendant at all until she sits down with you in your interview, correct?
That's correct.
And there's no mention of really any violence at all between the two of them prior to the night of the murder to anyone other than you, correct?
That's not correct because of the text messages that we discussed yesterday.
And so I thought what you had testified to yesterday was that in those text messages, there's no evidence of any physical abuse between the defendant and the victim.
That's not correct. I testified to the fact that Ms. Mericle comments on the fact that her head, about the injury to her head in early February, and she says something to Mr. Barron to the effect of, "You should be ashamed of yourself."
And then I stand corrected because there's also the actual physical abuse to Mr. Barron that the defendant admits to in text, correct?
Yes, it was a scratch.
And if there was a photo, let me ask you this, if there was a photograph of the defendant with a scratch on her face, would you be talking about it in such a diminished capacity as you are with Mr. Barron?
I don't know. I wouldn't. I would have to know the broader context. I do know the broader context of this.
Because of your assumptions of what the defendant is telling you to be the truth, correct?
And because I've seen a picture of Mr. Barron's face.
Sure, so let's say that that picture was a picture of the defendant's face with a scratch on it. Would your response to that be, oh, well, that was just a scratch though?
I don't know the context.
Okay. So, at the end of your report, you note it's well documented that Mr. Barron locked himself in a bedroom with both his phone and Ms. Mericle's phone, correct?
Correct.
Besides the defendant's own statements, where else is that documented? How else is that well documented?
It's in the police report.
Of the defendant's statements, correct?
Correct. It's in the police report. It's in the interview transcript.
Of the defendant's statements, correct?
Correct.
So when you say it's well documented based off of the defendant's own statements, correct?
I believe so, but I also believe in the police report, there's a statement to the effect of the phone was recovered.
Was it recovered in the bedroom?
I thought so.
Okay. Didn't read that it was recovered outside of the bedroom at the top of the stairs where the defendant was seen placing it down?
I did not.
Okay. I want to talk to you about the part of your report where you go into medical history and substance use.
Yes.
Okay. So you note in your report that she gave you a medical history including some hospitalizations, correct?
Yes.
And I think we've covered that those hospitalizations were not verified in any way by you.
Only by talking to her sisters who corroborated that happened.
Okay. And you note in your report that she does not have a diagnosis of ADHD, correct?
Correct.
But that she was taking Adderall.
Correct.
And then you note in your report, you make kind of go out of your way to note that Adderall is commonly abused. It's a drug that can be commonly abused, but in this case, there was no evidence of misuse by the defendant, correct?
That's correct.
Do you know why she was taking Adderall if she was not diagnosed ADHD?
So a lot of times people take Adderall even when they're not diagnosed with ADHD. They take it because they need to focus at work, or they take it, I mean, it's such a robust medication, it's such an effective medication that people will just take it when they need to concentrate extra.
And you would agree that drinking alcohol while taking Adderall can have very negative side effects, correct?
It's possible.
You would not advise one of your patients to drink multiple vodka drinks regularly while taking Adderall, correct?
That's correct.
And that's because Adderall can have dangerous side effects like intense emotional shifts, increased rage and aggression, and extreme irritability if you mix Adderall and alcohol, correct?
It's possible, yes.
What is Seroquel?
Seroquel is an antipsychotic medication that in lower doses is used to help a person sleep.
Did you confirm with her medical history that she was prescribed Seroquel for antipsychotic purposes or to help her sleep?
To help her sleep.
Where did you get that confirmation from?
Her sister had the medications from the drugstore.
So her sister just had the prescription?
Correct.
Did you get the medical records or notes explaining why she was prescribed that Seroquel?
It says it on the prescription. It says indicated for sleep.
And what about combining Seroquel, Adderall, and alcohol? Would you advise your patient against combining those three substances?
I would advise against that.
And is it because it can have similar side effects such as rage and aggression?
It's more, I don't think it would have side effects like rage and aggression. It would just make you like really sleepy.
Is your testimony that drinking alcohol while taking Adderall and Seroquel together could not possibly cause side effects or symptoms like emotional shifts, rage, aggression, or irritability?
It would cause rage and aggression. I have never seen that in 20 years of clinical practice. The combination of those three, never.
You have never seen someone describe drinking alcohol with Adderall causing anger or aggression?
You're asking with the combination of Seroquel too. Seroquel is so sedating. Alcohol is also so sedating that it more just makes you kind of loopy.
But Adderall is not sedating, correct?
Correct, but it wouldn't counteract. I mean, of those medications, Seroquel is the most powerful. So it would really be, someone like that would be like just kind of out of it and loopy.
How about on such a low dose of Seroquel?
Well, a low dose is, it seems like a low dose, but the low dose makes you sleepy. The higher the dose you go, that's if somebody's experiencing things like hallucinations, hearing voices.
Your testimony was that you would not advise someone taking all of those medications at the same time
Correct.
because it can cause significant negative side effects.
Correct.
Did she ever report to you why she flushed the shell casings or bullets down the toilet?
No.
Did you ask her?
Yeah, I mean, I take that back. I mean, she basically just said she panicked.
She panicked
Yes,
and decided to flush the bullets and the shell casings down the toilet.
that's correct.
Did she ever explain to you why she didn't attempt to provide first aid to Mr. Barron?
No, we didn't talk about that at all.
Did she ever mention to you the night prior to Mr. Barron's death, did she ever mention the defendant forcing her to perform oral sex on him?
No, the way that was told to me was the night of the offense.
Well, so I guess we kind of combine March 7th and March 8th together. So let's say the night of the offense, did she describe to you being forced to perform oral sex on Mr. Barron?
She did during our second meeting.
And did you not find that important to note in your report?
I did not.
You didn't think it would be important to note in your report that on the night where Mr. Barron was killed, he forcibly got the defendant's head and made her put her mouth on his penis?
The way that this was told to me, there were certain details that she was more consistent in. She mentioned that one time, so I kept in the things that I thought were most consistent.
So the reason you didn't mention it in your report that she said that was because you found it to be inconsistent with the other things she was saying?
It wasn't inconsistent, it just wasn't repeated.
Would it not be important to potentially note inconsistencies in your interview with the defendant?
Sure.
But you didn't note that in your report at all?
Well, it wasn't really inconsistent. It just wasn't a detail that she was saying over and over again in presenting her story.
But you're there to evaluate her for PTSD based off of trauma that she experienced by Mr. Barron, correct?
Correct.
And she disclosed to you that he forced her to commit aggravated sodomy on him, and you did not find that important enough to note in your report for this case.
I didn't put it in my report.
What about, did she disclose to you being forced to shave Mr. Barron's penis the night before she murdered him?
No.
She didn't mention that at all?
No.
I don't have any other questions. Thank you.
Wanted to circle back about abusers in intimate partner violence relationships and ask you some questions about that, okay?
Sure.
Okay. Do abusers in intimate partner violence cases, do they do things like affect the person's dress or the food they might be eating?
Yes.
One of the questions, well, I don't want to forget to ask you this too. And I think this is in the report on page 5. If you have your report, it's not the last paragraph, but the second to last tall paragraph of page 5.
I'm ready.
Okay. Did you note something in her interview with Investigator Mefford at the Law Enforcement Center where she makes a statement about, I don't know if I should tell you everything?
Yes.
Okay. Do you remember that statement being sandwiched between requests for his status and whether he was still alive?
That's correct.
What is the significance, from your standpoint, in a clinical sense and in a treatment sense, of asking if he's alive, then making the statement, I don't know if I should tell you everything, and then asking again if he's alive, and then not telling, basically, about this prior violence?
Well, the significance here is that Ms. Mericle asks repeatedly whether or not Mr. Barron is alive, and she's really never given that information. Even though it was known, it was known to investigator, it wasn't known to her. And so for all intents and purposes, she thinks that Mr. Barron is still alive. So long as she thinks that Mr. Barron is potentially alive, she remains in fear of him and isn't going to disclose.
Ms. Bennett asked you questions about the jail counseling that Ms. Mericle was provided.
Yes.
And you've stated that, she was told not to talk about the event with the counselor, but is it correct that she was reporting difficulty sleeping and hypervigilance?
That's correct.
Claustrophobia?
That's correct.
Did she report withdrawal and hopelessness?
Yes.
Was she presenting with a flat affect?
Yes.
And did the therapist note she was speaking in low tones with a monotone voice, making minimal eye contact?
That's correct.
Did she even make the statement to the therapist, I don't deserve anything better?
Yes.
Did she report recurrent nightmares?
Yes.
Intrusive thoughts?
Yes.
Did she talk about increased heart rate and sweating?
Yes.
Did she also describe feeling empty and numb?
Yes.
Was she observed with a slumped body posture by the therapist?
Yes.
Are these, did she appear with disheveled and fatigued?
Yes.
Did she have minimum eye contact and speak in soft, monotone, flat voice to the therapist?
Yes.
Is this consistent with a person suffering from post-traumatic stress disorder and other stuff?
Yes, that's a great way to characterize it. So some of these symptoms overlap, but some do not. Nightmares, the heart racing, the intrusive memories or intrusive thoughts, those are very specific to PTSD.
Ms. Bennett asked you questions about I think the word we were using was index event.
That's correct.
Okay. And maybe everybody knows exactly what we're talking about when we say index event, but index event in this case is, correct me if I'm not stating it right, it's the event identified by the person that has the post-traumatic stress disorder as the cause of this, or as the primary cause of what you said, exposure to a life-threatening event.
Yes, the most distressing event.
And for PTSD, it has to be exposure to a life-threatening event.
That's correct.
Judge, can I have the ILMA, please? Is the exposure to the life-threatening event, the index event that she identified was the pistol to her lips, correct?
Correct.
What you saw on the body cameras that you watched those 3 hours, is her behavior consistent or inconsistent with an acute trauma response to a life-threatening event?
Yes, it is consistent.
Last question. In your work with victims in intimate partner relationships, how does the abuser typically respond to information that the victim is moving on?
Angrily.
Is that something that the victim is going to respond to in any way other than with violence or anger, in your experience?
Could you repeat the question,
Yeah.
just so I understand?
When the victim is told and learns that there's a threat that when the abuser is told that the victim is now moving on in the intimate partner violence relationship,
Yes.
how is that abuser going to respond to this new information based on your experience?
So most often, the abuser will do something aggressive or violent to try and get the victim to stay in the relationship.
And is that consistent with the case file in this case, once Mr. Barron learned about Mr. English?
Correct.
Thank you.
Anything else?
No, Your Honor.
Thank you for your testimony. You may be excused.
Jim Persinger. This chair just so I can get back here again, so I don't have stuff on me. Is that okay? That's fine.
Welcome, come on up. Raise your right hand. You swear affirm the testimony about to give you the truth, whole truth, nothing but the truth, so help you God.
I shall.
Thank you so much. If you would have a seat, please speak in the microphone. State your full legal name.
Go ahead and state your name.
Jim Persinger, Persinger.
Judge, I'm sorry, can we approach?
Sure, come on up. All right, again, folks, lawyers just doing their job. Thank you so much.
Start again. Jim, if you could start at the beginning. Go ahead, state your name again, and give us a spelling.
Yeah, Jim Persinger, Persinger.
Tell the court and the members of the jury what you're currently doing, what your current employment is, and what your title is.
I'm the CEO of PM Investigations. I'm a digital forensics, cybercrime, and software developer that deals with data.
What sort of work is it that you do at PM Investigations? You stated some of that, but can you tell us what it is that you do there?
Well, outside of the administration information, I deal with data. So if you've got a computer, a cell phone, an SD card, CD, or anything that has data on it, I make what's called the forensic image of it. I then analyze that forensic image and extract information. If it's cybercrime, which is information that's happening currently, I go online, capture it, and then analyze it. And the software that I develop is primarily for law enforcement that deals with digital forensics and cybercrime.
What does a digital forensic specialist do specifically?
So again, I'll take data, and as I analyze it, I'll study some of the case elements, such as the incident and what took place, study the time, and then start to work on finding location of what we call the artifacts that is contained within that data and extract it. And then I'll put it into more or less a human readable format, something that's easy to understand and follow.
What does a cybercrime specialist do?
So what that specialist does is work closely with the internet. Somebody may be actually online posing as somebody, or is creating some kind of fake post, doing something to the internet that is currently underway. And I'll capture that information and track it to see if I can trace where the individual may be and what the contents may be about.
And what does a cell phone examiner do?
So with the cell phone analysis, again, I'll make a forensic image of it, and that image is equal to what's on the cell phone. I'll then load it up into forensic software to start analyzing it, again, studying part of the case file to look for artifacts that will help isolate what we're trying to learn about that particular data.
Can you tell us roughly how many cases as a digital forensic specialist that you've been involved with?
Over the past 25 years, I've been involved with over 5,000 cases. I've analyzed over 6,000 devices.
25,000. It was 25 years, and you said, and I got the 1,000 wrong. I missed it. Sorry.
Yeah, about 5,000 cases, and then there's close to 1,000 different cell phones that I've also analyzed, so about 6,000 total devices from a computer to a memory card to a cell phone.
And are these civil, criminal, both types of cases?
They're both.
Have you conducted any investigations into cell phones as part of your involvement in these various cases that you've listed out?
I'm sorry, could you ask the question
Have you
again?
conducted any investigation of cell phones as part of those 5,000 cases?
I have.
Roughly how many cases have you been involved with that involve cell phones?
Well, of the cases, about 600, again, about 1,000 cell phone devices.
Okay. Now, when we say cell phone, that can mean different, I guess, brands or types, correct?
Correct.
So have you worked on both Android phones and iPhones?
Yeah, that's correct.
So we retained you in this case, is that correct?
That's correct.
In some of the cases that you've worked on in the past, have you been retained by the government or the state?
That's correct.
And have you been on both sides of cases in both criminal cases and civil cases?
That's correct.
Briefly, just tell us what types of cases you've been involved in especially on the criminal side and then also on the civil side?
Well, for the criminal side, everything from murder, child pornography, intellectual property theft, hacking, any kind of data that really involved anything that may have been where somebody maybe took pictures, analyzing the metadata to determine when the picture was physically taken, to cell phone records, analyzing those to see when they were hitting particular cell towers, just about any kind of case you could imagine, from your simple theft up to your murder cases. On the civil side, it's been not only accident investigations, again, your intellectual property thefts, your divorce cases, which I don't do many of anymore, but the data that encompasses those civil cases can stretch even from people that are sending emails that were forged or, trying to be somebody else.
Can you tell us something about your work prior to being at PM Investigations?
Well, again, those prior cases are going to be a plethora of different types, from analyzing pictures to videos to documents, seeing when they were created, if they were opened, if they were deleted, how they were deleted, what the individual used to obtain the data. The processes are pretty much endless. I mean, I've been in technology for about 40 years. I've been a software developer for almost 35 years. I've learned to write code so that I can extract certain pieces of elements from the data to make those artifacts so we can understand it.
Did you also work in law enforcement for a period of time?
I did.
Can you tell us about that?
I retired from Cobb County Police. After my retirement, they called me back as kind of a consultant to help with the high-tech crime unit, to help them develop not only the material that they needed to start analyzing cases, but to get prepared for testifying and to get ready for the wave of technology as it comes to be.
Do you currently hold any kind of licensing, professional licensing, board memberships, things of that sort?
I do.
Tell us what those are.
So I'm a licensed private investigator. I'm a licensed private investigator instructor. I'm a post instructor. A post is police officer standard training. That means I can teach law enforcement and they get credit that is required for them to maintain their arrest powers.
And you teach them about digital forensics, basically.
That's correct.
I think maybe I'd asked you this before, but do you have any board memberships or other licenses besides being post certified and teaching at post? Do you have any board memberships?
Yeah, I'm also on what's called the American Digital Forensics Association, which is here in Atlanta, that is a organization that specifically outlines what a investigator needs to do, how they do the work that they do. I'm a prior on the board of ASU Dunwoody that does the course content for young investigators that want to become digital forensic specialists.
And just a short summary of education and training that you have, in addition to all the things you've already talked about.
Yeah, that's kind of what we've been talking about is, when I first got into this in 2000, there wasn't really digital forensics and cybercrime. So I started out doing extraction from hard drives to do data recovery to building websites. And I got a call from a then prosecutor who needed some assistance with data in a child pornography case and was able to help get that data off of the hard drive so that it stayed pure. And then as a follow-up that, a defense attorney hired me in a civil matter to recover lost money that was on a hard drive where we found the secretary was stealing from the company, and that launched the career.
You mentioned you teach at post, which is for most, I think all officers have to go through post before they get certified as law enforcement officer. Is that correct?
That's correct.
Have you taught at other agencies besides just our local post agency here in Georgia?
I have.
Where have you taught as in
The
addition to post?
FBI, the GBI, Secret Service, Homeland Security, several different law enforcement agencies around the United States, the sheriff's departments.
Have you done research and writing in the field that you work in digital forensics?
I have.
Have you produced any content or done any software development in the field of digital forensics? You mentioned this a little bit, but I wanted to make sure that you lay this out there too.
Yes, I have. One of the software applications I developed is called Field Search. I have 32,000 plus law enforcement agencies worldwide, from our military, the Canadian Border Police, down to Australia. Just about every law enforcement agency that is close to Georgia is using Field Search that allows them to quickly analyze data, extract the data into a PDF format for prosecution.
And this was a software that you made. Is that correct?
Yes, I developed it. We're now on the 5th version, and it's been out for about 12 years, 13 years.
Do you hold any patents?
I do.
Can you tell us about those?
First was ICE, in case of internet emergency. I'm the first with the 911 button for children, where a children feels threatened at school, could be through cyberbullying, could be through anything that is dealing at home, that the child would push this button, it would collect certain pieces of information, allow the child to write a sentence or two about what's going on, and the information gets disseminated to those of authority. And then the authority would analyze that information and decide what to do about the situation. The other one's called Iron Shield. Iron Shield is a firewall that is one of the first. It's like 36 Rubik's Cubes inside one Rubik's Cube that's constantly changing patterns. And it keeps your network safe beyond safe, so that by the time somebody got into it and figured out the algorithm, 20 years would pass, therefore the data would be useless to an individual.
Have you ever been qualified as an expert in court?
I have.
Can you give us an approximate number of times that you've been tendered and accepted as an expert in court?
Dozens of times.
And can you give this court an example where you've been qualified as an expert?
Just about every county of Georgia, to New York, California, Florida, South Carolina, North Carolina, the federal district here in Georgia, both the middle and the south and the northern, and other federal courts around the United States.
Have there been times you've been called as an expert by the court itself?
I have. It's what they sometimes call the expert's expert. I've had situations where two experts were analyzing data. They couldn't make a determination as to what the data said. The court called me to make a determination as to which part of the artifacts were more accurate.
Judge, at this time, we are tendering Mr. Persinger as an expert in digital forensics and cellular data.
No objections.
So ordered. Again, folks, as with any witness, believe the witness, don't believe the witness. Thank you so much.
How was it that you got involved in this case?
Through your office, you had made contact with me regarding 2 cell phone extractions that was done by law enforcement.
The 2 cell phones, I think you've sort of identified them by color, is kind of how you thought of them. So can you tell us what those 2 cell phones are and how you've identified those?
So the 2 cell phones are iPhones. One is a 11 and the other one is a 13. The 11 I consider to be the gray phone, and the 13 I consider to be the blue phone.
Now, you said iPhone 11 and iPhone 13. Probably every single person probably knows exactly what you're talking about, but can you just make sure that it's super clear what you're talking about when you say 11 and 13?
So that's generally the make and the model of that particular phone. As we all hope, when we get a new phone, that there's been improvements. So as the cell phone goes up in the number, it's supposed to be better than the last one. So an iPhone 11 and a 13 would be therefore better, according to Apple standards, than the 11. They may share some of the same functionality, but there would be improvements from one or the other.
And the gray phone is the 11 or the 13?
Is the 11.
Okay. And what you're calling a blue phone is the 13?
That's correct.
Did you undertake to determine, well, first of all, is it possible by looking at data on phones to determine whether phones have done things like climb stairs?
It is.
Okay. Is it possible by looking at data on phones to determine basically a good idea about when those phones may have climbed upstairs, and can you tell us how we can know that?
Yes, there is a way. Now, I want you to consider if you take a public library and you have multiple bookshelves. You might have one for American history, you have one for the automobile, and you have one, let's say, for gardening. Well, I know through experience that I'm going to go work on a car. I'm not going to go to the American history or the gardening. I'm going to focus on the automobile. Same thing with the phone. So I know that when I start to look at data and I want to see what that phone's doing, I'm going to look at, for example, if I want to see if it's doing any kind of emailing, I'm going to look at the email data. Or if somebody is surfing the internet, I'm going to look at the Safari, because these are Apple. I'm going to look at the Safari databases to see what that person may have been doing or the phone was doing. So when I'm trying to determine if a phone had made movement, one of the best apps that's on that database is the Health app. And in that Health app has a database, and that database will tell me, with a little bit of math, what's going on.
How does a phone know that it is being moved up a set of stairs or taking a step up, if you will?
So this is where my hardware experience came in handy. Inside of an iPhone is called an accelerometer. And what it does is not only measure the X, Y, but also the Z. So it's moving around. It's going left or right, up and down, and at angles. And when that chip inside, that integrated circuit, senses movement, it puts that movement in that health database. That's how it knows how many flights of stairs you've walked, how many steps you've taken, is that it's recording that information in that little database because that little integrated circuit.
What is the difference between steps, which you've just talked about based on the accelerometer, and let's say like geolocation, like, you know, because there's another thing with GPS and geolocation. Can you explain what the difference is?
Yeah, so I'll start you from the high level. We talk about a cell tower, for example. A cell tower's radius is going to be 3 to 7 miles generally. You may get a little more, you may be a little less, but it's just a generalized area. You move to GPS, you're going to be within 300 feet of the particular mark, which is amazing because you've got a satellite a million miles away and you're 300 feet in your distance. Your geofencing could be anywhere between 30 to 50 feet. But when you're dealing with the steps, it's going to be within a normal person's step space. So we know that on average, a step is 8 inches. So it knows through the use of that integrated circuit that the phone has taken a step up because it has seen that sense, that 8 inches movement going upward.
Does the data help us to determine, I guess, how many steps? Can we say for sure that this was a certain number of steps by looking at the data? Or does it just tell us when we dive into it, and maybe I'm not explaining this very well, that's where I want you to help me. when we dive into it, can it tell us when it starts and when it ends? What can we get from it is what I'm getting at.
It gives us that. It does give us a start, and it does give us an end. And it does that calculation based on the average size of a step, and it knows that when you've cleared X number of steps, 9 for example, that you've probably reached either a platform or you've reached the top of the step. And then it calculates that.
Did you take a look at the blue phone and the gray phone to determine steps specifically related to a time period to determine if these phones had climbed stairs?
I did.
Were you asked to try to determine if the phones climbed the stairs at the same time?
Yes, I was asked that, and I was able to determine that.
You were able to determine whether both the blue phone and the gray phone climbed the stairs at the same instance, at the same time?
That's correct.
Did you generate a document to, I guess, record that, record the time that the phones climbed the stairs together?
I did.
Show you Defendant's Exhibit 70 and 71. Our first witness, I'm sorry. Showing you 70 and 71. Can you take a look at these?
Yeah. Yes, I'm familiar with them.
And you recognize those?
I do.
Are these the exhibits that you created to, I guess, recount the conclusion about the phones climbing the stairs at the same time?
They are.
Do they fairly and accurately represent those conclusions?
They do.
Defense 70 and 71 move to no.
No objections.
Admitted. Which of these two is the one that you would like to talk about first?
Well, certainly Exhibit 3, because that's more of the details, and where number 2 is, Exhibit 70 is more of the summary of it.
Gotcha. So we'll look at Defendant's Exhibit 71, okay? Looking at 71, tell us about what you see on gray and blue, and explain to us kind of what we're looking at.
So the data that you see, this is actually from an Excel spreadsheet that gets captured into a JPEG that I add to the report. But the data that you actually see written in here is not me typing it. It is a copy and paste from the actual database, that STEPS database that I mentioned earlier, into the Excel spreadsheet format. And it starts off with the gray and the blues as on the far left, and then we start talking about the times. The flight climbed is auto-calculated by the software. So again, it's not me putting in a 1 there. It's a copy from the database over into this Excel spreadsheet.
One thing I notice is it doesn't tell us when it starts. It just says a time, right, for both of them?
Correct.
What accounts for the, I guess it's like a 12-second difference between gray and blue there on 106.17 and 106.29?
Well, again, I mentioned a little bit about the two different phones. You have an iPhone 11, you have an iPhone 13. But even if you had two 13s, even if those phones were bought at the same store at the same time, they're going to operate differently. Why? You have two different users. Those users have different apps. They use their apps differently. They do updates differently. So when you have this close time to one to the other, 12 seconds is more of a lag time of just one reporting to the other one. It's not because the phone is trailing behind. It is nothing more than a lag time.
In other words, is your conclusion, looking at all the data, the background data, the math, that these phones both climbed the stairs together?
They were together, yes.
Now, the flights climbed is giving us this general idea, 1:06 a.m. as the time that the flight was done climbing. Is that right?
That's right.
Is there, and did you look for any data about whether the blue phone, that'd be Miss Mericle's phone, whether the blue phone, after it climbs the flight up, whether it ever runs back down again, whether it does another flight, in other words?
I did look for that, yes.
Does it exist in the data at all?
It does not.
Is this support for the idea that the phone only went up the stairs and never came back down the stairs?
I won't say never came back down, but they didn't come back down together within a time period that I would expect.
And in other words, after the 106 climb, is there evidence of that phone coming down the stairs within the next 10 or 20 minutes?
There is not.
If our 911 call is roughly 1:10 a.m., 1:11, something like that, that's about roughly, am I correct? It's about 3, maybe 4 minutes before the 911 call?
That's correct.
I want to move on now, okay? I'm going to ask you about whether, I asked you to look at one other thing. I'm going to show you 199R. That was previously admitted.
Yes, I'm familiar with the document.
Okay. And let me put this on the overhead so everybody can get a look at it. Did we ask you to take a look at this search, 10:19 p.m., March 7th, with a deleted notation on it?
Yes, you did ask me that.
What did we want you to look for in the data to see? What did we want you to look for about that deleted entry?
Well, we wanted to see if two things, if it were factually deleted and if we could potentially tell when it was deleted.
Okay. In your work in digital forensics, have you done searches in the data like this in the past to see if something was searched for and deleted?
I have.
Is that something you do a lot of?
I do a lot of, yes.
Okay. Did you do a search to see if in the data this information was ever searched for and ever deleted?
I searched for that, and at first, my data was showing it was not deleted. And so I went back to the document that was provided, and it's saying yes, where my data was saying it was not. For clarification, Cellebrite, which is the digital forensic software that most of us use, comes in two different flavors. It comes in what's called Physical Analyzer. Now, they also have a new name for it, but during this era, it was Physical Analyzer. And what Physical Analyzer does is loads up that forensic image so that people like me can now look at the data, and it will tell us if data is deleted or not. That's what I started with, and I could not see that this entry was marked as deleted. The second tool that they come out with is called Cellebrite Reader. Now, what Reader's job is to allow a person that are unfamiliar with Cellebrite to look at the data, to load the data up without the expensive tool of Celebrite Physical Analyzer. Well, because I couldn't see it in Physical Analyzer, I loaded it up in Reader, the same Reader that was provided by the Sheriff's Department. And it showed truly that it was marked as deleted. So I asked myself, why does Physical Analyzer not show it, but Reader does? Through my investigation and a phone call to Celebrite, Celebrite told me that there was a version that they incorrectly identified entries as being deleted when factually they were not. So because I was running a more updated version of the software, I then created a Reader version of the most current software, and it showed that entry as not deleted. So it's a case of using older software gave misinformation.
May I approach the witness?
Yes.
All right. It's a bad habit, Judge. Show you Defendant's Exhibit 72. Is that a report that you did after and during this investigation, or whether this search ever took place?
Yes, this is my document.
And just to, well, let's go ahead and do it. In this document in 72, you're kind of, well, tell me what you're doing in 72.
So I'm working with the Reader version, and I'm working with my Physical Analyzer. And I'm trying to determine, why does exhibit that I looked at earlier have that column marked as deleted? And so I'm studying that, and you see in this document why it's not, is that it's mischaracterized by the forensic software.
And do all three of those pages sort of document your travel through this investigation?
They do.
Moving to tender Defendant 72.
No objections.
Admitted.
Tell us what we're looking at in Exhibit 7. Just walk us through that, and then we'll go to the next page.
So in this one, where the red arrow is pointing to the upper right, is the search term that I put in. I'm dealing with thousands of pieces of data within Physical Analyzer, and I'm trying to isolate that match the exhibit that we had up on the screen prior. And when I do that, it will return anything that has those search terms in it. And you see I have 11 of them showing on this screen that none of them are marked as deleted. You would know it was deleted because in that column that's right there in that center box, you see it says deleted, no. And that means that none of those indicators are saying that any of those entries are factually deleted.
Looking at the next page of that, can we see that exhibit that we just talked about contained in your PDF here?
Yes, and so what I was doing in this case is I said, because I had that other exhibit that was already up, I had some dates and times. I wanted to see if I could find at least the other ones that were not marked as deleted. And that's what this page is indicating, is that I truly have a match. So I know that we're looking at some of the same data.
Did you find that, and we'll look at this last page and I'll ask you this next question. Did you find that the search for the sheriff's office, county, jail, and Hall County had actually been done on the phone on some date?
Yes, it was.
What date was it searched for?
It was March the 3rd. And you see that the second entry is when it actually first appeared.
And show us, if you can, on the screen, where the March the 3rd notation is.
So that would, I don't know, the second entry that's there line number 2.
Line 2, okay? And how is it, in your investigation of this particular question, how is it that the Sheriff's Office, County Jail, and Hall, if it was searched for on March the 3rd, how is it that it returns during a reader search on Celebrite on March the 7th?
All I could speculate is there may have been a filter set only looking at March the 7th. My search was encompassed anywhere in the data. Remember, we talked about that library and going to that particular bookshelf. I know I'm dealing with a Safari entry that has some kind of database related to it. So I'm instructing the search to look in that history and find those terms, no matter where they are, in not only Reader, but then in Physical Analyzer. And then that's where I can determine, as in this screen, we see the little red X. That's if I'm using the old outdated reader that has the mischaracterization of the data, showing it has been deleted when factually it's not.
If a person has, let's say, well, is there such a thing called tabs when you're using Safari on an iPhone?
There is.
Okay. If a person has tabs on their phone from past searches, well, tell everybody knows what this is, but just explain it in professional terms, what a tab is.
So back in the old days of cell phone, you could only open up one website, and then you had to get rid of that website if you wanted to go to another one. Well, they introduced tabs so that you could have multiple websites, and you just put the tab kind of to the background if you're looking for something new. So you want to go to Google one day, that may be a tab, and then you want to look up movie times, and you might go to movietimes.com, might be another tab, and those two tabs are going to go back and forth with one another. If you close the tab's no longer theoretically available to you, but the data is still going to show that you had a tab that was open for that particular website.
Is there something related to tabs that can give us an answer about why, on the reader at least, it's claiming this is being dealt with or searched for on March the 7th?
Yeah, so two different tables within that one database. So I want you to consider that everybody in this room may have a bank account. Let's say we all bank at one particular bank, Ameris. And with Ameris, we all have separate accounts. Well, we all have different amounts in our accounts. Now, I'll take you back to the cell phone. With the cell phone, each app may have a separate database and may have within that database separate tables. And the job of each one of those tables is different. So in the Safari world, there is one that may deal directly with just you surfing, you searching for something out. But then there's one that deals directly with tabs. And then there's one called the browser state. And that works closely with the tabs that says, what did the person do? Did they close it? Or did they just put it in the back? Or is it in the foreground? And while it's doing all of this, that database is keeping up with it.
To recap, looking at Defendant 71, what is your opinion about these two phones going up the stairs at 1:06 a.m.?
So they are together.
And what is your opinion with respect to searching and deleting the Sheriff's Office, County Jail, Hall County on March the 7th, 2025 at 10:29 or 10:30 p.m.?
That entry is not deleted.
Thank you. Those are all my questions.
I don't need a break, Judge. No, I'm good.
Hi.
Good morning.
Good morning.
morning. So I just have a few questions for you. How do you say your last name again?
Persinger.
Persinger, okay. So you were retained by the defense on or about May 8th, 2025?
That's correct.
Okay, let's talk about how much you have been paid.
Okay.
How much did you get paid?
I usually make about $75 an hour. The company gets a retainer, and then by the time everything's done with, I'm about $75 an hour.
Okay, so how much do you estimate again? I think you got paid?
How much do I estimate? I'm sorry.
That you were paid?
I believe the initial retainer may have been $3,000, $5,000, somewhere in there.
Okay, and how much, I assume that you're being separately paid to testify?
I am.
How much is that?
I'm $370 or $350 an hour.
$350 an hour, does that include travel time?
Yes.
And you're based in Atlanta?
I'm sorry. Can you slow down just a tad? And
Yeah, I'm so
I got
sorry.
old ears here.
You're based in Atlanta?
I am, but I live out of Bartow County.
Where's that?
Yeah, it's about 2.5 hour drive from here.
Wow, okay, that's pretty far. So, and you said, okay, so you get paid with the travel time, and that's still $75 an hour?
No, the drive time to testify is $350 an hour.
Gotcha, okay, thank you so much. So, let's see. It is about 10:24, so took you about 2.5 hours, so maybe like an extra $1,000 for testifying, maybe, if I wrap it up?
That's what the company would make, yes, and then I would
Okay.
get my $75 an hour out of that.
Okay, so I just want to talk to you, and you and I have spoke, aside from today, I would say 2 separate times, right?
If I recall correctly, I think it was once, and you had 2 other assistants or other attorneys and investigator with you on the phone.
But prior to that, do you remember when I tried to call you at end of February? We spoke on the phone, and do you remember when you told me at that point, this is February 27th, that, and I quote, that you had no idea what you were testifying about?
That's correct. I had just gotten out of the emergency room not too soon before that.
And you were previously retained, and you were retained on the 8th of May, 2025?
That's correct.
Okay, so I want to talk to you about today. So you came in this morning, what time you think?
Probably about 9:15, 9:20.
9:15, 9:20. And in the hallway, you met, I guess, there's somebody from the defense in the hallway meeting you, right?
As
I
well,
think it's the blonde, she's blonde, kind of dirty blonde.
yeah, her, but I met with you first.
You met with me first.
Not you, it was another one from your office first.
Okay, but you weren't able to speak to her, correct?
No, I was headed to the bathroom.
Okay, so you're headed to the bathroom, and then the blonde chick came to you, and she said, "We need to hide you," correct?
No, she said she had some questions for me.
Okay.
Let me approach, y'all approach for a second. All right, thank y'all.
So now we're talking right now. You were retained by the defense to determine what cell phones were doing at the time of the incident.
I think I was retained by defense to first understand what the data was. I don't think there was any pinpointing anything. It was, there's 2 cell phones that were imaged by the sheriff's department that in most cases attorney can't access because of one reason or another. Celebrate, the physical analyzer runs about $10,000 to $25,000 a year. So most attorneys don't have that software to be able to do any kind of data dive into it to determine what's there. And so it was up to me to mount it, look at it, and then get ready to investigate it.
Sorry, I'm just quoting from your report. This is on page 3 where you said specifically to determine what these devices were doing near the time of the incident.
Yeah, that came afterwards, yes.
Okay. And to do that, you looked at a few different things on the phone. From what I remember, you looked at the timelines of the phone, correct?
I did.
And you also looked at Apple Health.
I did.
And within that, you looked at, I guess you were able to analyze steps, you were able to see flights climbed and whatnot.
That's correct.
Okay. So I want to talk about, I guess, the phones exactly. Both of these were iPhones, correct?
Correct.
And when we're talking about steps, you and I both spoke about this on the phone. The iPhones aren't exactly accurate or always accurate with calculating steps, correct?
I would agree with that.
Okay, in fact, if I wanted to increase my step count, I could take my phone and shake it a whole bunch to increase that step count, and it could hypothetically increase those steps, right?
I haven't tried that before, so if, I don't have one in iPhone, but two, I've not tried that, so I can't say.
So you said that in your report, it is, okay, 1:06:29 a.m., the blue iPhone traveled up a flight of stairs, correct?
Correct.
Okay. And then you note that there is a 12-second lag time that could be present, right?
Correct.
Oh. Yeah, can you please take that down? Thank you. So there's a 12-second time difference that could easily represent a normal lag time between one device and another, correct?
Correct.
Okay. Could easily represent does not mean definitively represents, correct?
No, I mean, I don't own the phone, so I don't know what its experience is. But I know that in dealing with cell phones throughout my career, two phones aren't going to operate the same. So again, one could be lagging behind the other.
Okay, one could be lagging. So that, I guess, fast forwarding to this, there's no standard lag time for a phone.
None that I'm aware of, but again, in this particular case, we have two cell phones that I strongly believe went up the stairs together, and they did not come down.
Okay, and they didn't come down. So I want to pose a hypothetical to you. Two people are walking up the stairs. Standard, and let me, before I get to that, a standard flight of steps is what, 12 steps?
I don't know, my house only has 9.
Okay. So I want to ask, I guess prior to the hypothetical, in your report, you talk about different integers that represent how you can tell that if somebody's going up a flight of steps, somebody that's taking a few steps. I think they were like 7, 8, and 12 or something.
Yeah, 7, 8, and 12 is what I tend to focus on.
Okay, 7, 8, and 12. And does the 12 represent a flight of steps or not?
Yeah, 12 represents that a flight has been achieved.
Okay, so how does the phone calculate that a flight has been achieved? Based on how many steps?
Well, based on 7 and 8. So 7 is going to say a step, 8 is going to say the distance traveled. So between 7, 8, 7, 8, 7, 8, it says, I've gotten to this calculation height, therefore a flight must have been established.
Okay. So if two phones were traveling together up a number of steps, let's just say 7 or 8, and they get to a landing, and so the flight isn't exactly, all the way up, diagonal, they get up a flight of steps, there's a landing, and then there's a number of steps, let's just say 6.
Okay.
The phone data would represent that, what? That they walked up a few steps, but they didn't exactly get to a flight, correct?
Well, I couldn't say either way because, again, I don't know what the stride is. If somebody's running up a flight of stairs, maybe they missed the landing. They just made the turn to the next step and just continued up. We don't know that.
So back to the hypothetical, two people are walking up a flight of steps. One person is 10 seconds in front of the other. Based on the data, pulling the data, you don't have a normal lag time amount. You don't know, every phone's different, I understand that. But it's quite possible that you would conclude that those phones are physically together, correct?
Yes, it's my belief, my understanding that those two phones are together. And again, that those phones stayed up there. They didn't come down one by one. They stayed up there.
Okay, but I'm talking about the hypothetical.
Yes, I am too. I'm saying hypothetically, if those two phones are upstairs and that's where they stay, and there's only a 12-second lag time between one phone and another phone, they're together.
By together, and by a report, you're saying physically together, correct?
Yes.
But if the person A is walking in front of person B, 10 seconds in front of them on the steps, they're going higher, faster, we know that they are not physically together. But the data would show that they were, correct?
Yes.
Okay. So going back to this case at hand, you can't say definitively what flight of steps their phones were going up, right?
Ask the question again.
So you can't say what flight of steps, like where locationally in the house.
Correct.
Okay. And you can't say who was carrying those phones up the flight of steps.
That's correct.
Okay. And your opinion is you strongly believe, but you cannot definitively say that the phones were together, correct?
I believe that they are together.
Okay, but you can't definitively say that. It's not 100%.
I say it's highly possible that those phones were together.
Okay. So let's talk about the search for the Hall County Jail. I believe that you said, I guess the initial search, and I don't have it up. Do you have your exhibit?
Your document?
The one that you put up, the one we just put up. Oh, great, thank you. So this is, I'm just looking at Defendant's Exhibit 72. So you said it's quite possible that she had a tab open.
Yeah, yes, on the 3rd.
Okay, on the 3rd, so she searched it on the 3rd. Yes?
Yes.
Okay. And then are you saying that she left the tab, like she did other searches on her phone and she left the tab open in the browser?
Yes, because again, that browser allows you to have multiple tabs open at the same time. It's just that one's going to be in the background, one's going to be in the foreground.
So would I be correct in saying that if that was the case, that the timeline search of what she's searching would show from the 3rd to the 7th, so the 3rd, the 4th, the 5th, the 6th, the 7th, more searches for the Hall County Jail within that whole, I guess, Knowledge C database, correct?
I can't answer your question because I don't really follow what you're asking. If you're saying that because we have multiple entries, did she multiply search for that term? I'm not.
I can rephrase it. I think on direct, you testified that in back in the day, you would do a search for, I guess, one search at a time. And then I guess phones evolved and you were able to start opening up multiple tabs. So I want to look up Chick-fil-A and I want to look up McDonald's. And you could have both of them open on the phone and switch through.
Well, they're both open, but one's in the foreground, one's in the background.
Okay. So am I correct in saying that you believe that her search for the Hall County Jail was in the background?
It could have been. We don't know what was in the foreground or the background, but we do know this factually. March the 3rd is when it was first searched.
Okay, March the 3rd was when it
Not
was
in
first
your
searched.
document that showed later, March the 7th.
So on the March the 7th, based on this exhibit, I see it 1, 2, 3, 4, 5, 6, 7, 8. Oh, wait, just kidding. 3 times on the 7th, and you're saying that's because the tab was open.
That's correct.
So it's quite possible that she was in that tab looking at the search history and the results that popped up, correct?
Could have been, but it certainly wasn't deleted.
Okay, okay. No further questions.
Thank you, sir.
Thank you for your testimony. You're excused.
Thank you,
We're
Judge.
going to take a break. We'll call it 15 minutes. Thank you. Anything from the state?
No, Your Honor.
Anything from the defense? All lawyers approach, please. All lawyers approach, please.
I need to go that way.
Can I just ask, like, to explore in what way? You mean just like the bigger picture for like future whatever?
I will note, so back in,
All right, thank you so much. Welcome back.
need a paper clip.
Need a staple. All right, welcome back. Thank you so much. Of course, that one's out too. Sorry about that. All right, thank you so much. Please be seated.
Defense calls Dana Gardner.
All right, welcome. Thank you so much.
If you would please just stand and raise your right hand.
You can remain seated. That's fine. Raise your right hand.
Do you swear or affirm the testimony you're about to give in the matter now pending before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can put your hand down. Go ahead and state your full name and spell your last name for the court reporter.
My name is Dana Mericle Gardner, and the spelling of my last name is Gardner.
Your middle name is Mericle.
It is.
Okay. How is it that you know Suzanne Mericle?
She's my older sister.
How many siblings have you guys got in the Mericle family?
7, including me, and including my late twin sister.
Okay. You had a twin?
Yes.
Okay. Of the 7 siblings, who would you say is closest with Suzanne?
You know, in a big family, it goes around, and depending on the stage of your life and when you have kids and all, but Suzanne and I have been very, very close in, you know, the last decade. So, yes. Me.
So it's you, basically.
Mm-hmm.
Okay. Did you ever have the chance to meet David Barron?
I met him twice.
Okay. I want to talk to you about the first time that you met him, and I'm going to approach, who's
Me.
showing you Defendant 73. You recognize that?
I do.
Okay, what is that?
That is the Saturday of Georgia-Florida weekend in 2024. And we were there to watch the football game, or the first half, and Suzanne wanted me to meet David.
Is this a photo of you guys from that date?
Yes.
When you first met David Barron?
Correct.
Okay. Does it fairly and accurately represent the two of you on that same date that you met David Barron?
Yes, sir.
Move to tender 73.
No objections?
Admitted.
May I have the elbow check? Tell us where this is, first, city and all that stuff.
St. Simon's Island, Georgia, and Brogan's Restaurant.
You said it was the Georgia-Florida game, and I know that's typically at a certain time, but could you give us an orientation of, as close as you can, date?
Yes, it's always right around Halloween. It's either the last Saturday of October or the first Saturday in November, but that's where it falls.
Okay. Was this the first time that you ever met David Barron?
Yes,
Okay. Was that a long meeting with him that time, or just very brief?
very brief.
Did you have another occasion to meet Mr. Barron that was, I guess, longer than this first meeting for the Georgia-Florida game date?
I did.
Okay. Roughly when was that?
That was January 18th, 2025, at my sister's birthday.
January 18th, 2025, at your sister, which sister is this?
Leslie. It was her 60th birthday, and it was a surprise party.
Okay. Do you know her birthday offhand?
I do.
Okay. What is it?
January 18th.
That's how you know it was January 18th?
That's how I know, yes.
Was this, what kind of party was this? You said it's a birthday party, but are we talking about a small group of people? Are we talking about a larger group of people? Is this in public? Is it in private?
It was a private party, but it was a surprise party for Leslie with all of her close friends, so it was a large party. I'd venture to say 30 to 40 people, probably.
How many of the siblings, meaning the Mericles or the extended Mericles, were there?
All of them.
Did Suzanne come?
Yes,
And did Mr. Barron come?
he did.
Had you ever, before this night, before January 18th, 2025, had you ever had any conversations with Mr. Barron at all?
No, other than nice to meet you at Brogan's.
On this night, on this birthday party night, was Suzanne there with David as a couple?
Yes, they arrived together.
So this is his first time meeting the family, if you will?
Correct.
Okay. You've got 7 siblings, and she's got a new boyfriend, right?
Correct.
Was this one of those, let's see what's going on here kind of things?
Yeah, I'd say we were focused on Leslie for her birthday, but we were definitely looking forward to getting to know David.
Okay. What, if anything, did you notice about Suzanne and David's interaction on that weekend, on January 18th, at this party?
You know, they would interact some, but then I'd find them kind of sitting by themselves or over by the bar. This is a big barn property, and they have a nice party set up. And so they would be sitting over by the bar, chatting quietly, just to each other. And then Suzanne would come engage and play in this card game a little bit, but then he'd pull her back again, and they'd be talking again. And so it wasn't typical party behavior where everyone else was kind of engaged with everybody and walking around and talking to everybody. And then, we'd engage her again, and she'd come back and hang with us.
What did you conclude about, how had she up until this time behaved at parties like this, from your observations?
super fun and involved in all the fun stuff that was going on. We're all kind of gregarious and like to have fun, and kind of, she was the life of the party and having a great time.
Was that consistent with what you saw from her on 1/18/25?
No.
Now, you didn't see any violence between the two of them there?
No.
Did she talk to you at all about him later at any date, at any time around this time? What was she telling you about him?
Up until that time, nothing negative. Just, I didn't talk to her as much because she was, with him all the time. And it seemed like she was kind of molding her life around his. But I just assumed she was happy, and that was where she was heading, and they'd bought a house together, and she was kind of riding off into the sunset with her knight in shining armor.
Did you know about the purchase of the house in Hall County?
I did.
Was that something that the siblings and you thought was a good plan for her?
Not necessarily. We thought it moved very quickly, when that worried us.
Did she ever characterize Mr. Barron to you as a really good guy?
Yes.
At some point, did she start talking to you about some concerns with him?
Yes.
Were you aware of a paramour or another woman that potentially had been involved with Mr. Barron?
Yes.
Did Ms. Mericle talk to you about that?
Yes.
What was it that you were kind of serving as? What was your role when you're talking to Suzanne after these concerns about the other woman and I guess just dealing with her as her closest sibling?
I would just kind of let her speak and let her be heard, and to hope that she's okay. And she always knew that she could talk to me without judgment. And I just wanted to learn what was going on with her and try to help her and advise her.
And how were you helping and advising her? What were you trying to give her to assist her as she's dealing with the issue with Mr. Barron?
That, at the beginning, when she first found out about it, and he was saying that he was going to stop sending money, and she was like, okay, I'm going to give him the chance to do that. And then he showed his true colors, and he didn't stop doing that. And so I tried to help her end it, or advise her to, remind her that he has shown his true colors. We were always taught, when someone shows you who they are, believe them. But she just wanted to continue to see the good in him.
When you're talking to her about leaving, about ending the relationship, does it seem like it's getting through to her at periods of time?
Yes, at times.
Did she express to you wanting to leave that relationship?
Yes, over and over.
Did you notice after where she's kind of come over to the side of, I want to leave the relationship, did you notice that would change at some time?
Yes.
Tell me about that.
So and it wasn't just me. My sister Leslie and I spoke to her. She would kind of talk to both of us. And so when we would talk to her, she'd say, I know, y'all are right. You're right. I'm going to leave. I deserve better. I don't deserve this. I just want to be loved. And I thought he was the one. And so, but she would come around and say, okay, I'm going to do it. I'm going to leave. I'm not going to be with him anymore. And then she'd kind of drop off the face of the earth, and we would know that he had worked his way back into her, and then we wouldn't hear from her.
Were you even aware that she had been arrested and charged with DUI in Hall County?
No.
I want to talk about the weekend of March the 6th and the 7th, okay?
Okay.
Did you know ahead of time that she was going to be going to the lake house in Hall County? Were you aware of that? Did she say, I'm going to the lake house this weekend, if you recall?
Yes, I believe I was aware of that. Yes, in fact, I was aware because she had said he came down and surprised me. And I thought, oh no, here we go. He's pulling her back.
When March the 7th comes around, do you remember if you talked to her at all on that day?
No, I definitely had not.
Did you, on March the 8th, in the early morning hours, receive some calls from Ms. Mericle?
I did.
Did you answer those calls?
I did not.
When was the first time that you recognized that you had missed calls in the late night hours?
When I woke up the next morning, probably 8 o'clock in the morning, I'll guess.
When you saw the missed calls from Suzanne, what came to your mind?
I thought I need to check on her because I had calls from her in the past in midnight or later hours, and occasionally I would be up or I would hear the phone ring and I would answer, but most of the time I'd be asleep, so I would reach out to her the next morning, make sure she was okay. And so I thought I need to reach out to her again and make sure she's okay.
And were you able to make contact with her?
No.
What did you do next?
So I waited. I texted her and said, are you okay? I think I called her first. She didn't answer. And so I texted her and said, I missed your calls last night, just calling to make sure everything's okay, or checking in. And so I tried not to get alarmed. I just had a gut feeling. I just didn't feel good about it because she has her phone with her all the time. But I thought if she was up late, maybe she's sleeping in. I hope that's the case. So I just kind of let it go. And then a few hours later, I was really getting worried. I had this instinct. And so I texted her and said, if I don't hear from you by X time, and I don't know what time I gave, but I gave a number, a time period. And I said, I'm going to have someone come check on you because I'm really getting nervous. So, and in the meantime, I tried to nonchalantly call the kids to see, because she talks to her kids all the time, and especially Mary Madden. So I just, nonchalantly said, hey, have you talked to your mom today or heard from her? And Mary Madden said, no, what's wrong? And so I said, nothing, I missed a call, and I'm, just checking on her.
So now you've texted, called, reached out to her kids. Is your anxiety level going further and further and further?
Yes.
Are you very, very concerned at the time that
I'm getting very, very concerned.
Do you make a phone call to 911?
I do. That time came and passed, and I was like, I'm calling 911. I just was terrified that something bad had happened, because now hours have gone by and she has not called or texted me or her children, and we've all tried reaching her. And so I just had this elevated angst, and I was like, I'm not waiting. We've already lost another sister to domestic violence, and I'm not going to do it again.
Judge, I'm going to play State's Exhibit 1 starting at 5:22.
Hall County Dispatch, how may I help you?
Hi, I need to ask someone to do a welfare check on my sister.
Okay. And what's the address?
Okay, it is 4238 Bay Ridge Drive.
Okay, and what is your sister's name?
Suzanne, Suzanne, Mericle, M as in Mary, ERICLE.
And what's her date of birth?
How
old is she?
May 15th, 61, I think. I have 6 siblings. I can't keep track of all of them.
Okay. And tell me what happened.
So she has a lake house. We live on St. Simon's, and she has a lake house. And I woke up this morning to 2 missed calls from her in the middle of the night. And she has been in a not good relationship lately. And I don't know the guy very well, but I know he's a heavy drinker, and she's been trying to get out of that relationship. And he keeps pulling her back in. Well, I called her first thing when I woke up and saw the missed calls, and no answer. And I called her about an hour later, no answer. Text too. She lives with her phone. And so I said, I'm worried, call me. I'm about to call your children, which I knew she would not be happy with. So I called them, and so they haven't heard from her either since 8 o'clock last night. And they've been trying to call her, and she just would never not answer her phone. So then I called the boyfriend, David Barron, and his is going straight to voicemail. And this is just not like her. And just knowing that he's kind of isolating her. And I've been through this with another sister, and it turned out the worst case scenario. And I just have a feeling it is, I don't know. But the fact that I cannot get her is very unusual.
Okay. What's your phone number?
It's 912-996-4506.
And what is your name?
Dana Gardner. And her adult children have tried calling her, and I mean, she lives for them and would never not answer the phone.
Okay, so I'm going to have an officer call you. When they call, it'll come from a blocked, private, or unknown number, okay?
I will answer.
All right, I'll have them call you here shortly.
Awesome. Thank you so much.
You're welcome.
Bye.
Bye. Dispatch Monica.
Those are all my questions. Hold on.
Oh, yeah, sorry.
Hi, Ms. Gardner. Can you hear me if I just leave this right over here?
I sure can.
I just have a few questions for you.
Okay.
So, you established that you and Suzanne are sisters.
Yes.
Okay. And you're the older sister?
I'm the youngest.
Oh, I apologize. Suzanne is Suzanne the oldest?
No, she's in the middle.
Okay, she's in the middle. Okay, but in terms of sisters, you are the youngest?
Yes,
Okay. And you live on St. Simons, right?
I do.
Are you a realtor?
I am.
Okay. A realtor selling properties on St. Simons?
Mostly, but also on the mainland.
Okay. And at some point, you agreed to sell Suzanne's condo for?
Yes.
Okay. I want to just go over a few text messages that you had with Suzanne.
Okay. Excuse me.
I don't want to say your whole phone number out loud, but does it end in 4506?
It does.
Okay. And Suzanne's ends in 4039?
Yes.
Okay. This is. I just want to show you some text messages that you had with your sister. Do you mind just looking over these and see if you recognize them?
I don't have my glasses on, so this is a blur.
We're going to have, is there a way to shut off a TV but allow us to?
Can you get your readers?
My readers are with my husband.
Okay.
Let's accomplish that. Thank you.
Okay. Sorry, I should have brought them up with me.
You can go ahead, it's okay.
Thank you. Okay, it's still very small, but I can see it. Okay, what was the question?
If you could just flip through them and see if you recognize them, that would be great. Oh, yeah, I'm so sorry. I'm so sorry.
Yes, I recognize them.
Do they fairly and accurately depict the conversations or some of the conversations that you've had with Suzanne?
I haven't read them, the detail of them, but, because there's many pages here. Let's see. Yes.
Okay. I'll take that back from you. I promise it'll be pumped up to a bigger screen.
Okay.
At this point, the state moves to tender 199G.
And no further objection to 199G.
Do you mind?
Admitted. Going laptop or doc cam?
Laptop.
Oh, you do? I don't know. Yeah.
It's gonna be a lot bigger, I promise. Okay, so I believe I remember you talking about let me just find my notes. The 18th was your sister Leslie's 60th birthday?
That's correct.
Okay. And the date of these text messages that are up on the screen right now, they're January 20th, 2025.
Yes,
Oh, thank you so much. Okay, so 2 days after the party.
that's right.
So you say to her, and this is you, morning, everything okay, correct?
Yes,
And she says, it is good, I will talk to you later, love you.
yes,
And you say, love you too. Have a good weekend, correct?
yes. Have a good week.
Oh, have a good week, my apologies. And she says, you too, correct?
Yes,
So then at around 10:44 p.m. and change on the 20th, she says to you, are you awake? Yes?
yes,
Followed up by, you say, yes, what's up? Yes?
yes,
She says, I'm not sure what I need to do. You say, about, and she says, some words, and then about 3 or 4 weeks ago, I saw where David was texting with other women, and I confronted him, and now it's just blown up. That was sent by Suzanne, correct?
correct.
She says, what can somebody just love me, correct?
Correct.
Suzanne then says, and this is at 10:47, all I want is their love, their truth, their compassion, and loyalty.
Yes.
You say, oh crap.
I say, oh crap.
This message right here,
Okay.
and then followed up by a message of WTF, correct?
Yes, correct.
So then Suzanne says, why did he buy a house with me? All this feels like everything he told me is a lie. Yes?
Yes,
And she says, I know. Followed by, I'm in such shock. Yes?
yes,
And then asks you, please do not say anything. I am humiliated.
yes,
So then also says, hey, seem to be the best guy ever. Yes?
yes,
And to make sure, I know you also, just straying away from that for a second, you also had an interview with Dr. Elcon, one of the defense's experts, and this was on or about October 4th, 2025, right?
yes.
You guys spoke for about an hour and a half.
If you say. I
If
don't
you
know.
remember, if,
Possibly.
was that on the telephone? Or?
Yes.
Okay. So during that interview, you told Dr. Elcon that Suzanne consistently described David as a good guy with a good heart.
Yes,
And on direct, you said that Suzanne never disclosed any physical abuse that David allegedly had done to her, correct?
correct.
Okay. So I want to continue on from here.
Okay.
We are at this, if you can see my little mouse moving.
I do.
So at 10:49, I'm sure it feels awful right now, but texting isn't the end of the world. I know several people whose husbands have done the same, and they've worked through it and are stronger than ever.
Yes.
I would say that you're being pretty reasonable. Would you say so?
Yes.
Suzanne then says, I just keep fucking up. And you say, how is that your F up, right?
Yep.
Suzanne then says, I don't know what to do. I'm sick of this day. I bought a house with him. I believed him. Yes?
Yes.
And you say, would he be willing to go to couples therapy? Yes?
Yes.
And if so, I would jump right in with both feet. And that's from you, yes?
Yes.
Okay. So then she provides you with a little bit more information.
Correct.
I found out that he's supporting some woman in Romania and her daughter. Why did he introduce me to his family? Why did he take me on a trip with his family? Why did he want to meet my children? Why did he want to meet my siblings? Why did he want to buy a house with me? I'm just unlovable. Yes?
Yeah.
She then says, I want to sell my practice, just move somewhere that nobody knows me. Yes?
Mm-hmm.
And followed up by, I need to sell up. I need to sell my condo. I guess I need to sell that lake house. I don't want it.
Yep.
Then you say, y'all both have pasts. Supporting that woman and her child in Romania is not something he's probably very proud of. Did he tell you about it, or did you have to find out on your own?
Yeah.
She says, I'm not going to contact him. I'm tired of chasing. If he wants me to come, find me. I found out on my own. He was not honest with me. I asked him who she was when I saw her texting him, and he lied.
Yes.
She then says, I told him I don't mind texting other women as long as they are friends. I have guy friends.
Yes.
And then you guys have a conversation. This is probably about an hour and 27 minutes or so.
Yes.
So then your conversation ends for that day. At some point during your interview with Dr. Elcon, you told Dr. Elcon Suzanne needed a lot of attention and that she was very needy, right?
Yes.
So I want to continue on. This is on to the next day.
But there's a lot more to that context.
Okay, we can get into it in a little bit.
Okay.
Okay. So on the,
Witness wants to complete the answer that she can. So I think she could give the option instead of delaying if she wants to finish it.
We're going to continue with the examination. Go ahead.
so on the 21st, this is at 1:31 after your phone call. Suzanne says, thank you for always being there for me. I fuck up so much. I'm tired and I feel so unloved, but I do love myself and I will be strong. Thank you for always loving me and for keep me going. You are the best sister and friend I have. Please don't think bad of David. He's a good guy, but maybe not the guy for me, or maybe he is. I love you. Yes?
Yes.
You say to him, to her, I apologize, I love you, don't worry, I give everyone the benefit of the doubt. Let's get you through the next day or two, and the path will become clear. Ask God to surround you by all of your guardian angels, of which you have many. Mama will be leading the pack and will help guide you.
Yes.
So then Suzanne says a little bit after that, I don't know when you should contact him. I don't want him to feel attacked. I want him to know it's from love. He is such a good man and he has such a good heart. This is so hard because I know he never meant to hurt me. I really believe he loves me, just doesn't know how to love me. Yes?
Yes.
So I want to ask you about that first sentence. Suzanne asked you to contact him?
In the phone call, I think I volunteered. The phone call that we talked.
Okay, you volunteered to
A little later.
contact him.
Yeah, I wanted to help. And I was alarmed to hear about this woman, and I wanted to help get to the bottom of it. And was he going to stop? And did he really love her? And is he the one? And I just wanted to help and see if I could help them, I don't know, be some sort of mediator and see if they could get through it. As I mentioned earlier, I knew friends who had gone through some things, and they'd gotten through it and had been very open and loving with their friend group and about everything. And I have had experience in that and saw that it could happen. And so I thought perhaps this could happen too for them.
Did you ultimately end up contacting David?
No.
No. Okay. I want to continue with the text messages.
Okay.
We are at this box right here. You say, "Don't worry, I'm not calling him, at least not without talking things through with you first. Let's digest all of this and I'll check in on you tomorrow. Love you."
Okay.
Yes?
Yes.
Okay, then at some point she modifies her contact for some reason. And then y'all have another phone call in the evening for about 13 minutes, yes?
Yes.
So then that evening, a little bit after the phone call, Suzanne tells you, can you put in her phone number? I think you have to put 001R code from the US before the numbers. Yes?
Yes.
So this might not work, but. It's really small.
I see it.
Whose name is that? Oh, my goodness.
Lilia, I don't know if it was Bocan or how you say her last name.
Okay, so at some point, she asks you to contact Lilia.
Yes, I actually volunteered not to contact her.
Okay.
I asked her for her contact information.
Okay, did you end up contacting her?
Oh, no, it was not to reach out to her. I was looking, as a realtor, we use an app called Forewarn.
Okay.
And it can give me background information on people who, making sure to know where they live and to know if they have a background or anything like that. And so I wanted to know where she lived. If he was sending money, I was just curious where they lived and where the apartment was.
Okay. So at some point in this conversation that you had with Suzanne on the 21st, she volunteers this information about Lilia to you, and you are going to look her up further. But she also appears to have her phone number as well, yes?
That Suzanne has her phone number? Yes.
She sent you, okay.
Yeah, correct.
So on the 21st, continuing on, you talk about the app may only work on US numbers, but I'll see, and this is the app that you were talking about?
Correct.
So she says, okay. You say, any news? She says, can you talk? And then y'all have a conversation for about 10 minutes, yes?
Yes.
So this is later, this is on the 24th. At some point, she sends you a screenshot. Do you know what that was of? Sorry, I gotta.
Okay.
We're getting there, we're getting there, we're getting there. It's pretty small.
It's really blurry up here.
Okay, it's really blurry. It looks like a text conversation, but let's try to read some text messages to see if we can put some context in it. She says this was his response, right?
In that text message that you just screenshotted, that's what you're reading to me now?
This one that is right underneath, so the first one that you can see, the first full box.
Yes, I'm asking, is that what is said in that that screenshot that you had up there?
No, so we can't read that. I can zoom in on it, but I don't think we'll be able to read it. But she's texting you here,
Okay.
124, and she said this was his response.
Okay.
Was that about David, if you recall?
I'm sure he called Hope Powers back. I don't know. I can't say for sure.
That's okay. So she says he responded. I'm sure he called Hope Powers back, and I just sent the text again, and he answered, going to eat, question mark, question mark, question mark, and then there's a period in there.
Yes.
She says, I'm going to leave him alone. I'm going to focus on selling my practice in the condo, and then I'll focus on what I want to do with that lake house, may want to keep it.
Yes.
You reacted to the message, and then you loved another message, and then y'all had another conversation for about an hour or so.
Okay.
Right?
Yes.
So then on the 24th, Suzanne tells you, please send the PDF on David. Right?
Yes.
What is she referencing?
Where I put David's phone number in that same Forewarn app, as I thought, who is this guy and who are these people he's dealing with? This seems like, this is all a surprise to her and someone she's been living with for months. I'm going to look him up as her sister. And so I put him in the Forewarn app and sent the report that came out with it.
Okay. So she then says, we're just going to continue on with the text messages. Wow, this is crazy. I found both Lilia Bocan and an Emily Estrada on Facebook. She's from Romania, but they don't look poor? Question mark, question mark, question mark.
That's right, because we assumed they were poor because that would be why he was a good guy helping them, not a mistress or someone like that. And so it totally turned everything. We were like, this is a different deal.
Okay. But at this point, you had absolutely no idea why David was allegedly sending Lilia money, right?
No, we thought he was being a kind man sending money to a family we made it, like I said, we give everyone the benefit of the doubt. That's how our mom was and how she taught us to be. So we were trying to hope and pray it was a good reason and that maybe that would become clear. But then when she found them on Facebook, it made us think differently.
So she finds them on Facebook. Does she send you screen captures of the Facebook accounts?
Not that I recall.
Okay. So Suzanne then says, I'm not sure if that's the same person the other day. I did show that picture to David and I said, this is Lily. He said, no, that's not her, but she does have black hair. Suzanne then says, he has not called me even though I want some answers. I do not know, or I do not want to have to reach out to him. I want to call him, but I know that's probably not the best thing to do, right?
Yes.
So you then say, even if you call him, he's likely not to give you the answers that you seek. If he was, he'd call you as you asked. Take a shower and put on a movie and try to get your mind off of him.
Yes.
Still then, you're being pretty reasonable. Would you agree?
Yes, I'm trying to counsel her and calm her and help her have a good night's rest. Yeah.
So still on the 24th, she says, she being Suzanne, I have decided, Dana, I cannot reach out to him anymore. If he texts me, I'll just respond. We need to talk. I'm so confused. I'm going to relax and watch a movie.
Yes.
She then says, I am feeling better every day. You and Leslie have helped me so much because I've been able to talk it out.
Yes.
So to confirm, she also talked to Leslie about David and Lilia.
Yes.
At some point, you do call her and, okay, then you're talking about real estate, Okay. Then you talk about real estate, and that's essentially the end of your conversation with Suzanne about Lilia and David. Yes. So then
On the text, yes.
yeah, on the text messages. So I want to get to the calls that you received from Suzanne.
Yeah.
So I don't know if we have it up here. Take a second to try and find an exhibit.
Okay.
So on the night of the, or I guess very, very, very early morning on the 8th, were you aware of what time Suzanne called 911?
I am now, but of course I didn't know then. I mean, I've heard I've been to the motion hearing and the bond hearing, so I heard a lot of stuff then.
Okay. So you're aware that Suzanne called 911 a few times? Not exactly the times, but you know she called.
I know she called, that's correct.
Were you aware that after she called 911, I would say, I think about 6 minutes after she called 911, she called you?
I didn't know the timing.
Okay. You got phone calls from Suzanne, I think about, let's check, I have it right here. Maybe, okay, 1:15 a.m.? Oh, I apologize, this is, I'm looking at 199D. Yes. So she calls you at about 1:15 a.m.,
Okay.
if you remember.
I saw the calls the next day, and I remember it being after 1 and before 1:30, but I can't recall exactly the exact.
So from your knowledge from the motions hearing and whatnot, you remember that she called, after she calls you, she then calls 911 again,
Okay.
yes?
Yes, again, I didn't know what order, but yes.
And then she calls you again at around 1:22, yes?
Yes, I saw that on my phone.
Okay. Did she leave you a voicemail?
No.
So I want to get back to what you were saying about the Leslie's birthday party.
Yes.
So you said that was the first time that you had any direct contact with David.
That I'd spent more time in a room with him, but the first time I had contact with him was the Georgia-Florida game at Brogan's restaurant.
Florida game. And that was November 2nd? Or that weekend,
That's
like
right.
October 31st?
Yeah,
or
first
something?
Saturday of November, that could have been November 2nd.
Okay, so then you also told Dr. Elcon that aside from the party that you hadn't had any direct contact with David before that party. So,
Correct.
okay, so you're saying that at the Georgia-Florida game, he was just kind of there and you didn't really interact? Okay.
There was a group of us. We weren't sitting or anything. We were just standing and getting a spot to watch the kickoff. And so, you know how girls will kind of get together and guys will get together. And so Suzanne and I had not seen each other in a while, so we were hanging out together with a couple of our friends.
So on January 17th, I believe that's Leslie's birthday party?
18th.
18th, I'm so sorry. And you said about 30 to 40 people were there,
Rough estimate, yes.
rough estimate. It sounds like family members.
And friends.
And it was at a barn?
One of Leslie's best friends has a really nice property, and right next to it is, they call it the barn, but it's not an actual barn. It's this really nice property where they keep things, but they also clear it out, and they have birthday parties and cookouts and things there. It overlooks the marsh, and it's really pretty.
Oh, it sounds really nice. So this 60th birthday party was being held there. It's private, Suzanne's family is there, and this is in St. Simons.
This is actually in Brunswick, just over the bridge on the mainland.
So at the time, you said, let me just make sure. Okay, so on direct, you said that David was kind of pulling her away and they'd be talking and then they'd separate and whatnot. I believe you also told Dr. Elcon that he was a bit possessive of her. So, but this was the first time that you've had direct contact with him. And there's about 30 to 40 people at a party, yes?
Yes.
You just got to give an affirmative because the court reporter's taking notes. 30, 40 people at a party. And David, to your knowledge, is not from St. Simons or Brunswick, right?
Right.
So, I mean, to your knowledge, Suzanne was the only person that he probably knew, right?
True, but we're all super friendly, and everyone walked up and said hello and introduced him, and, he could have interacted, and we certainly tried to interact with him. And when I say they weren't sitting over there like he was holding his hand, there was talk, whatever was happening with them. It just seemed off.
Right, and that's the 18th, so that's, I guess, did Suzanne tell you when she found out about Lilia?
A couple days after this party, she told me about it.
Okay, so she told you about it a few days after, but she didn't tell you when exactly
She did tell me that she was in a car with him. She didn't tell me the exact date, or maybe she said, I know they were heading to a furniture store, I believe, in a vehicle. And she found a text came in on his phone, and he had said, I think he wanted her to put directions in to the phone. And so she was doing that, and a text came in from, I believe, Lilia. And that she was like, what is this? And he reached over and was trying to grab the phone from her and wouldn't explain to her what it was. It's nothing, and flew off the handle. And they ended up not going to the furniture store. And she was like, just explain to me what it is. And he just wouldn't. And so that's where all that began.
And that information came from Suzanne?
Suzanne, yes. But she had held it. She was embarrassed. She didn't want to tell me about it. But then it all started coming to a head. And that's when she told me about it. But she, like she said in her text to me, I was humiliated. And she was heartbroken. And she was hoping beyond hope that they would get through it. And that he would be the person she thought he was.
So just a little bit of a timeline. So the 18th is Leslie's 60th birthday. These conversations kind of started on the 20th.
Yeah.
It's safe to assume, and would you agree with me, that Suzanne found out about Lilia prior to the birthday party?
Yeah, that's what I think some of the talk may have been. I don't really know. But yes, and she told me about it. I think maybe that long phone call that we had could have been when she told me the details.
So you'd agree with me in saying it's quite possible that David was in an uncomfortable environment and he's quibbling with Suzanne about this Lilia chick, so he may be uncomfortable.
Maybe, but she painted him as someone who was also the life of the party. This is not the person we saw who she described. You know, she loved being, you know, when she went down to his family, they had a good time, and she thought, you know, it was all great. So that was not a person that she described sitting in that room.
And you said, I apologize, Suzanne never told you about any physical abuse that David allegedly committed against her?
No.
And David never likewise told you about any sort of sexual abuse that David did against Suzanne?
No.
I'd like to ask you about February 2nd, 2025. So at some point early in the morning, and you talked about this with Dr. Elcon, that you missed a call from Suzanne, and that you knew that she was in the emergency room.
I did not know she was in the emergency room, no.
Okay, so that must have,
Just
never mind.
probably a missed call. That would happen in I believe, the heat of the moment. And I would call her back the next day, and she would say, oh, it was a butt dial. But I knew in my heart that it wasn't, because by the morning, she would have gotten a clearer head, and then she would be embarrassed and not want to tell me what happened. Because by then, you know, they had, you know, sort of made up, and again, she was trying to paint him in a light to us that he was a good guy.
You also said, so I guess you got a call from her then, and Suzanne said it was a butt dial. You also got a call from Suzanne on or about February 16th or 17th, 2025, and that was the day that she was arrested for DUI, yes?
I did not get a call that night that I recall. Perhaps, but I don't recall that.
Okay. Well, do you have the timeline from the 16th and 17th? Oh. Let me check what number it is.
I think Mary Madden did, but not me, I don't think.
Well, it's fine. You don't recall?
In fact, I was out of town that weekend, and I would have called to make sure she was okay and reached out to her, and we did not speak that weekend or text back and forth. I was, you know, with some friends, and I think I would remember that.
Okay.
But I do know that Mary Madden had a missed call from her.
You did say, though, on direct that David surprised her that weekend. So this is the weekend of the 17th, that she told you, or you were aware that David surprised her.
I don't know exactly which weekend, but when it happened, he's like, he surprised me. I'm going to go over to the lake next weekend. And I thought, okay.
Were you aware that David only came because Suzanne lied to David about a medical issue she had been having? No further questions.
Thank you for your testimony. You can, you're excused. You can remain in the gallery, go back to business.
Anthony's Kavanagh.
Y'all come up real quick.
Oh, I'll go up first.
We're going to do one more witness and then take a lunch break. Thank you. All right, thank you so much. All right, welcome, come on up. If you would raise your right hand, you swear affirm the testimony about to give you the truth, whole truth, nothing but the truth, so help you God.
Yes, sir.
Thank you so much. You can have a seat, speak into the microphone. If you would state your full legal name.
Anthony David Kavanagh.
Thank you.
And Mr. Kavanagh, can you tell the jury how you are employed? I work for Hall County Fire Rescue as a firefighter paramedic.
Firefighter paramedic. And how long have you been working with Hall County?
About 9.5 years.
9.5 years. And your current position, I think I heard you said firefighter paramedic?
Yes, sir.
Okay. Can you explain to the jury and talk to them about, for lack of a better term, the different levels of emergency personnel within the fire department?
So I am a FAO, which is a fire apparatus operator. So in layman's terms, I drive a fire truck. I also hold the certification of paramedic, which I can ride on the ambulance as the lead personnel. As far as the EMS side goes, you have a EMT-B, an EMT-A, and a paramedic. So you have a basic, advanced, and then paramedic. So majority of the people that work for Hall County, we're pretty much all of us almost are advanced EMTs at least, and then you can go further your education.
Is there when you're hired by a Hall County Fire Department, is there a training that they'll put you through before they ever put you onto a med unit or an ambulance?
Yes. So we have a recruit school. So we have our own fire school. So we do all of our fire training, and then there have been times we've had our own EMT program, and then there have been times where we use other agencies like Lanier Tech to house our EMS program.
And was that training that you went through?
I went through Lanier Tech for my EMT-B and EMT-A, and then Faithful Guardian for my paramedic.
Faithful Guardian,
which is an EMT school or EMS school.
EMS school. And is that done in order to rise to the level or be promoted to paramedic?
Yes.
Okay. I want to talk to you a little bit about the early morning of March 8th, 2025, okay? You know the date that I'm talking about, right?
Yes.
And specifically responding to 4238 Bay Ridge Drive in Gainesville.
Yes, sir.
Okay. At that time, okay, so a little over a year ago, what role or position did you hold within the fire department?
Paramedic.
Paramedic, okay. So by March 8th, 2025, you've already gone through the training, EMTB, EMTA, and then further training, be paramedic.
Yes, sir.
Okay. For this particular call out to 4238 Bay Ridge Drive, what was your role during that call in terms of responsibilities, duties?
I was the lead medic on scene.
Lead medic on scene?
Yes, sir.
Okay. Do you have a copy of your report?
Not on me.
Okay. Judge, permission for free reign?
Thank you, sir.
And I'm not gonna tender anything, just if he needs it to refresh or watch. It's not gonna get. Okay. Just, I want to talk to you a little bit about some of the information contained in the report. I know we're talking about something that happened over a year ago. I'm sure you guys get plenty of calls. So if at any point you just need to refresh your recollection, take a beat, and then we can talk about it. Okay?
Yes, sir.
Okay. Specifically, I want to turn to page 4 of this report, okay? And can you tell the jury what time your med unit, and is med unit another word for what we would think of as ambulance?
Yes, sir.
Okay. What time did your med unit arrive on scene at 4238 Bay Ridge Drive?
It's 1:27 and 49 seconds.
Okay. And then, is this a situation where you immediately arrived on scene and then entered the residence, or did something else happen?
So as far as the on-scene time goes, it's pretty much you pull up to the house, put the truck in park, press on scene.
Okay, on scene. And then is there a different data point for when you actually get to the patient?
Yes, sir.
Okay. And what time did you actually get to the patient?
The patient arrival time was 1:28 and 32 seconds.
So in this instance, we're talking about less than a minute in between arriving on scene and getting up to the patient?
Yes, sir.
Okay. And you remember where patient was located at the scene?
Upstairs bedroom on the right, directly behind the door.
I want to talk to you a little bit about rigor mortis, okay? Can you explain to the jury what rigor mortis is?
Rigor mortis is when the body, you go into cardiac arrest, and after a certain period of time, roughly 1 to 6 hours, then the body starts to harden. Like it just everything becomes stiff. The first thing that becomes stiff is typically your jaw, but eventually everything, you'll be stiff as a board, essentially.
Okay. Is it possible for somebody to die and then their body not to experience or develop rigor mortis?
To my knowledge, no.
Let me talk to you a little bit about lividity, okay? Similarly, can you explain to the jury what lividity is?
So lividity is the pooling of blood. So after we pass away, our heart stops beating, gravity takes effect, all the blood just seeps down wherever gravity's taking it, and then you'll have like bruising on the body. which usually takes anywhere from 20, 30 minutes to 2 hours.
Okay. So in an instance where somebody has placed a 911 call at 110, 111, and then you're at the patient by 128, it's at least possible that the onset of this lividity could be happening.
It could, yeah.
And again, I guess, is lividity, unlike rigor mortis, sort of more dependent upon the position the body is in after sustaining some sort of injury?
The evidence of lividity, yes, like what you see. So if you're laying on your stomach, then I would expect to see lividity all over your chest, wall, and stomach and everything.
Again, that's essentially a discoloration of what we would normally expect a body to look like.
Yes, sir.
Okay. PEA, you're familiar with the acronym?
Yes, sir.
Okay. Can you tell the jury what PEA is?
PEA is pulseless electrical activity. So after the heart stops beating, there's a lack of oxygen, or PEA is due to a lack of oxygen or volume loss, so a loss of blood. After the heart stops beating, you have electrical impulses that are still flowing through the heart, but it is not creating an actual contraction. So there is no palpable pulse, meaning when you check for a pulse, you can't feel anything.
Would it be fair to describe it sort of, the heart is thinking that it should pump or beat, but it simply lacks the physical capability. So it's sending these signals out, beat, pump, but it just no longer, because of loss of blood or whatever injury, possesses the actual physical capability to perform that function.
Yes.
Now, I want to talk to you a little bit about when you get up to the patient in the bedroom, okay? Did you check for a pulse?
Yes, sir.
Okay. And I guess, how did you do that?
When we found the patient, he was laying on his stomach. We rolled him to his back, checked for a carotid pulse, no more than 10 seconds, and then you immediately start CPR.
Do you remember, let me ask you this, do you remember the body was light, heavy?
He's a heavy guy, he's a big guy.
Okay. I think, did you have to, eventually, we're jumping ahead a little bit, but let me go ahead and ask you, eventually, did you transport the patient from the bedroom to the med unit?
Yes, sir.
Okay. And what did you use to do that?
It's called a mega mover, which
Okay.
is basically a tarp with handles.
Okay. And was the decision to use that due in some part or all part just to the size of the patient that you were dealing with?
The mega mover was determined by the layout of the house. So typically we would use a backboard, but because the stairwell, there was a turn, then it would make it a little bit more difficult. So we chose to use a mega mover.
Gotcha. Okay. So can't detect a pulse, and then did you have any equipment with you that's also used to detect rhythms?
Yes, we had our cardiac monitor.
Okay. And the cardiac monitor, that can detect all sorts of different rhythms, right?
Yes.
And rhythm, can you explain to the jury what a rhythm is?
So a rhythm is the electrical pathway that your heart uses to make a contraction. So you'll have typically, what we all hopefully have is normal sinus rhythm.
And the monitor that then are looking for the results, is the monitor able to differentiate whether this is, a regular rhythm, I think VTAC, PEA, anything like that?
Yes, When we attach the pads to the patient, it's a manual interpretation, so it's what we see. We can use a function on the monitor to then get its assessment, but the PEA that we're describing here is our manual interpretation.
And by that, do you mean observing the results that you're seeing on the cardiac monitor in addition to other observations like not being able to feel a pulse?
Yes. So the monitor indicated that the heart had electrical currency running through it, but without a pulse, it is called PEA.
Okay. Now, the body of the patient that you were dealing with, was it warm to the touch when
Yes.
you got up there? Okay. Was there any rigor mortis that had set in?
No.
Was any lividity set in?
No.
What do you know the rate of PEA, the PEA rhythm that was detected?
23.
Okay. Were all of these factors, because was it you who had the responsibility of whether to transport the patient to the hospital or not?
Yes.
Okay. Were all of these factors that you just described, did those go into your decision to transport the patient to the hospital?
Yes.
Okay. Are there some situations or some calls that you respond to where you don't transport the patient?
Yes.
And simply the patient and the patient's body is left on scene and you guys return to service?
Yes.
But at least for this instance, there were enough factors where you felt that the right decision was to transport?
Yes, sir.
Okay. And would that be consistent with the patient having recently received the injury that you guys were dealing with treating, recently received in connection with your arrival time to the scene?
I don't understand.
Okay. The condition of the patient's body.
Yes.
Right, as you arrive on scene, is that consistent with a body that's recently received the traumatic injury?
Yes. Yeah.
Okay, thank you.
No questions.
Thank you for your testimony. You're excused.
Thank you.
Everybody hold tight, let the witness clear, and we'll take a lunch break. I will see everyone at 1:30. Let's hold for the witness to be excused. Thank you. All right, members of the jury, thank you so much for your time. Again, please do not discuss the case with anyone, do not perform any research. Thank you. 1:30. Anything from the state?
No, Your Honor.
Anything from the defense?
No, sir.
See you back at 1:30. Thank you. If anyone cares, the conversation is that closings are likely to occur Thursday morning.
Thank you, Judge.
The testimony you're about to provide before this court and the matter pending before it shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Okay. Get a little bit closer to that microphone just so everybody can hear you, okay? Can you state your full name, please?
McLean Harrison Culver.
And how do you know the defendant, Miss Suzanne Mericle?
Dr. Mericle is my mother.
I want to talk to you about 4238 Bay Ridge Drive, okay? Do you know the residence that I'm talking about?
I do.
Okay. Did you ever have an opportunity or an occasion to actually live there?
I did.
Okay. And we're going to get into it a little bit later, but approximately how long did you live there?
Roughly like 3 weeks or so. Just 3 or 4 weeks, depending on time.
Okay. And that would have been when?
That would have been moving in on January 2nd, technically, and then moving out sometime in late January. I don't know the specific date I left.
Of what year?
Of 2025. Last year.
2025. Okay. So last January.
Right.
Okay. I'm going to show you some pictures. If you'll just look at these, and then when you're done looking at them, let me ask you some questions, okay?
Okay.
Do you recognize what's depicted in those pictures?
Yes, it's the kitchen entrance area, pantry area.
Okay, of
4238 Bay Ridge.
And do these pictures accurately and truly reflect the way the kitchen area and pantry area appeared at 4238 Bay Ridge Drive?
Yes.
Judge, move to tender defendant's exhibit 82, 83, 84.
No objection.
If I could have that.
Admitted.
Hello, please. Can you just describe for the jury what we're looking at here in Defendant's 82?
Sure. So on the right side is the front door to the home, and then as you pan to the left, stairway that goes down to the basement level. Staircase obviously goes up to the top floor. Then you have the fridge to the left of the stairs, and then where the microwave is, there's a pantry area back there with other cabinets.
Okay, so if we're looking like through sort of that archway and you see a microwave?
Right.
Okay, that's
the pantry.
Where's the pointer? This what you're talking about, pantry area?
Yes.
And in Defendant's 83, what do we see here?
To see more of the kitchen area, the fridge would be more to the right, but then you can just see more clearly the pantry, and then that door and the pantry room leads to the garage, but just more of the kitchen.
So this door leads where?
To the garage.
Okay. And then through this archway, where would we be going into?
Into the pantry.
Judge, can we go computer?
I'm going to play you a portion of a body cam, okay? Just watch it. Will you make sure it's mute? I would just go all the way down, just to be safe. We're going to play from 7:57 of this body cam till about 8:12 of the body cam, so just a 15-second snippet. If you'll pay attention, and then I'm going to have some questions, okay? And Judge, just for purposes of the record, this is a body cam video from, I think, is it Lieutenant Feraldo? We had previously discussed this with the state, and they didn't have any objection to us putting this body cam into this witness without sort of the normal procedures that we would have done with Lieutenant Feraldo. So again, that was about 7:57 to 8:12 of his body cam. Do you recognize the room depicted in this body cam?
Yes, I do.
Okay. And that room
As
is?
pantry.
Okay. In that body cam, did you notice any keys laying on top of any of the counters?
I did not pick up on any keys in the video.
Okay. Judge, at this time, we move to tender Defendant's 87, which is Lieutenant Feraldo's body cam video.
No objection, Judge.
Admitted.
Approach with some more pictures. Again, same process. Take a look. Let me know when you're done. Do these appear to be still shots from that body cam that we just watched?
Sorry?
Do they appear to be still shots or screenshots?
They do, yes.
Judge, at this time, I would move to admit defendants 76, 77, 78, 79, 80, and 81.
No objection, Judge.
Admitted.
And if I could get the Elmo again, Judge. Going to show you and go over with you what's been labeled Defendant's Exhibit 78, okay? On that countertop, in the pantry, do you see any sets of keys anywhere?
I don't think I see any keys in this photo.
And again, in Defendant's Exhibit 80, a slightly different angle, same question. In that pantry, on the countertop, do you see any sets of keys visible?
I don't see any keys in this photo.
I want to talk to you a little bit about the neighborhood of 4238 Bay Ridge Drive. Okay. Judge, again, at this time, I'd move to admit or tender Defendant's Exhibit 86, which I believe the court's authorized to take judicial notice of. It's a Google map printout just showing travel route from 4238 Bay Ridge Drive to Clarks Bridge Road, which is the nearest main intersection. So we move to admit that.
No objection.
Okay, so I'll accept it into evidence, that's fine. And then, do you need anything else from me?
Not at this moment.
Okay.
Take a look at this. Now, when you were living at 4238 Bay Ridge Drive, what were you doing there?
Well, living there, but working remotely.
What was your daily sort of day-to-day routine?
Get up 6 or so, and then work till about 7, and then just make dinner. And pretty boring.
And then would you stay there Monday through Friday, Monday through Saturday, Sunday to Sunday?
Yeah, usually Thursdays I would drive down to Atlanta and see my friends from college that still live in Atlanta.
Okay.
Then come back late Sunday night or something.
Okay. So would drive to and from house to Atlanta, other places, and back and forth, right?
Yeah.
Okay. The map that I showed you, does that fairly and accurately depict the route that you would take to get to the lake house if you were turning off of Clarks Bridge Road?
Yes, it does.
Okay. Do you have permission to publish this?
Yes.
This road right here, which road is this?
Clarks Bridge? Clarks Bridge, is that what it says? I'm bad at remembering names of roads, but
Can you see it on there?
Clarks Bridge?
Yep.
Clark something.
Okay. And then do you remember the name of the road that you would turn off of to get to the Lake House neighborhood?
Yeah, I guess I'll double check myself, but C. Rogers, I think it is.
And that's sort of this main road right there, right?
Right, it's the main road off of that. It takes you to the lake house.
Does that road, does it dead end into the neighborhood of 4238 Bay Ridge?
It does, yes.
So is 4238 Bay Ridge Drive, this little piece of road right here?
Yes, it's near where your pin is, yeah.
Did you ever have opportunity to travel this route at night?
Multiple times, like, yeah, before work or after work.
When it was dark out?
It was dark out, yeah.
Okay. And inside the neighborhood, let me talk to you a little bit about this. Inside the neighborhood, how many houses are there?
I'd say roughly 9 homes, 8 homes, I'm not entirely sure.
Starting from when you turn onto Bay Ridge Drive?
When you turn on, I think there's 1 or 2 houses to the right of the 4238 Bay Ridge.
So up this way?
No, when you turn onto Bay Ridge Drive, there's like 2 homes before 4238 on the right, and then a couple after that.
And then when we get down to 4238 Bay Ridge, is there a house, if you're looking at the house, is there a house to the right?
There's a house to the right.
House across the street?
Yes.
And then are there any houses, if you're facing the house, to the left of the house?
Facing the house, I think there's 2 homes to the left of it, not including the one that's directly across from it.
For the period of time that you were living there, did you ever see anybody occupying the house across the street?
I never saw anybody in that house.
Right. Did you ever see any cars going into the house?
No.
The time that you're living there, which again is January 2025, did you have any interactions with any neighbors?
No interactions, just saw the neighbor that lived to the right maybe less than a handful of times, a couple of times.
Okay. And again, were you working from home?
I was working from home, yeah.
So the majority of the time that you're in Hall County, would it be fair to say was spent at 4238 Bay Ridge Drive?
Yes.
Okay. And the only neighbors that you ever saw were from the house to the right if you're facing the house?
Correct.
So never saw any of the people that occupied houses to the left?
I do recall seeing a couple cars after a week or two there, and I didn't even know there was a house there, but I never would see them often.
No, and no interactions with them?
No interactions with them, no.
Not even a wave?
I don't think so, no.
Now, prior to coming to court today, did you have the opportunity to review a video?
I did.
Okay. And what did that video depict?
The video depicted just Bay Ridge Drive and C. Rogers Road, or Drive, I'm not sure, but just at nighttime.
At nighttime?
Right.
When it was dark out?
When it was dark out.
Okay. Did that video truly and accurately capture and depict what it would look like to travel from 4238 Bay Ridge Drive all the way up to C. Rogers Road and then on to C. Rogers Road?
Yes, it would show the exact street at nighttime. So
during night when it's dark outside?
Right.
And Judge, at this time, we would move to tender Defendant's Exhibit 85, which is the video that we're talking about right now.
No objection.
Admitted.
Permission to publish that?
Yes.
Pause for just a moment here, just to talk about. So this portion that we've just seen, which road is this?
Bay Ridge Drive.
Okay. And then Bay Ridge Drive is what, again, leads to C. Rogers, which is the only street out of the neighborhood.
Right.
And at the point that the video ends, is that still C. Rogers Road?
It would still be C. Rogers Road.
Okay.
Yes.
And does C. Rogers Road continue on to look like that until you get to the intersection?
Yes, and leaving it and then go uphill from there, but yeah, same thing.
I want to talk to you about the first time you ever went to 4238 Bay Ridge Drive, okay? Do you remember when that was?
That was Christmas Eve of 2024.
I think we could guess what the purpose was, but could you tell the jury a little bit more about why you went there?
Sure, it was for us all to celebrate Christmas together.
And who is we?
It was myself, my sister, brother, both of their partners, I guess, the sister-in-law and sister's boyfriend, and then my mom and David.
Okay. You're one of three siblings?
One of three siblings.
Okay. Are you the oldest?
I'm the middle child.
Okay. Who's the oldest?
Mills is the oldest.
Okay. So was Mills's wife there?
Mills's wife was there.
Okay. And then you're the middle child?
The middle child.
And then who's the youngest?
And Mary Madden is the youngest.
Mary Madden. And her boyfriend was there?
Her boyfriend was there.
Okay. And then your mom?
My mom.
And Mr. Barron?
Right.
Okay. And this is the first time that you've ever been?
First time I've ever been to
this
that house.
Okay. What, if anything, stood out to you as odd or out of the ordinary during that trip?
So a couple of things stood out that were odd. My mom was kind of in like a more reserved, almost like submissive personality or way of acting, and that's like really different than as I've known her to act. And then, I mean, there were several things. And then also night one, so usually Christmas time or really any holiday or when we're all together, we love to play games, board games. And we like everybody to get involved. And David was not able to play really, couldn't really like even speak at a certain point of Christmas Eve because he had drank so much and was like almost falling asleep, it seemed. But it was really early in the night. So that was kind of just like immediately really weird.
Is this the first time that all of your mom's kids, children, you, your brother, and your sister have been together to spend time with her and Mr. Barron?
That was the first time all of us were together.
What else seemed off or out of the ordinary to you?
Yeah, I mean, just overall, how my mom was acting was weird. And
what do you mean by that?
For example, like there was, before we played board games, David, Mr. Barron, he wanted some ice cream. My mom said, sure, I'll get some as well. And it was almost like him like telling her to finish all of it. It was not just like, it was like a lot of ice cream for someone to be served that. And also my mom had like a lot of gastrointestinal issues the past like couple years and probably should not have been doing that. And it was almost like he was, I don't know, telling her to like finish all this ice cream. And that was prior to him becoming like almost nonverbal. That kind of started out the weekend, just a really weird state for me. So.
Okay. And how long did you end up spending at 4238 Bay Ridge Drive this trip?
So I left the day after Christmas on the 26th.
On the 26th, okay. And then when did you next return?
So I came back on January 2nd. I spent New Year's in Atlanta and then came back to the lake house on the 2nd.
And the purpose for coming back to the lake house on the 2nd was what?
So they had said, you know, I could work remotely there and live in the basement bedroom. And so I said, sure, sounds great. So that was my like move-in date, if you will.
Okay. When you returned to 4238 Bay Ridge Drive on January 2nd of, was it 2025?
2025.
Was anybody there at the lake house?
No, it was just me.
Okay. Do you know where your mom and Mr. Barron were?
I knew they were on St. Simon's for New Year's because they had both told me that. So we had talked about plans and whatnot.
I want to talk to you a little bit about your mom's hearing ability, okay? Can you tell the jury how long your mom has had difficulties with her hearing?
Sure. So as long as I can remember, she's always had trouble hearing. Like we would pick restaurants that were, you know, more, I guess, quieter than others. Otherwise, I knew she would not be able to hear us, or we'd be able to like have a real conversation. And so, yeah, I mean, and then she got her implant in, which I know helps. And she had another hearing aid that she would supplement with the implant, but has had really bad hearing issues for as long as I can recall.
Let me talk to you a little bit. So what efforts would you have to undertake to make sure she could either hear you exactly, certainly, you know, make sure that she was understanding precisely what you were saying?
Sure. So, I mean, even like in the car with her, like, it can't be like a ton of extra music or like loud music because you wouldn't be able to talk to her. And then in restaurants, we walk in, ask for like a table, and there's like loud music, and it's like, we're trying to catch up or actually have a chat. Like, that would not be possible. Or it would just not be a fruitful conversation.
I'm going to show you a couple of documents, and then you let me know if they look familiar to you, okay?
Yes, they do.
Okay. What's depicted in these documents?
These are texts between myself and my mom.
Okay. And are these true and accurate copies of the text message conversation you had with your mom starting on March 7th?
They are.
Judge, at this time, I move that tender admit defendant's exhibit 74.
No objection.
That's collectively 74
Yes, this is all 74.
admitted.
And if I could, thank you, Judge. Who's in the blue? Is that you or your mom?
That's me in the blue.
Okay. So you reach out to her just with a sup madre.
That's me, yes.
And let her know at Cole's B-Day party.
Yep, that's still me. Yep.
And can you see what time it is that you're letting her know that you're at Cole's
It
B-Day
says
party?
8:46 p.m.
And then you get a response from her at what time?
8:48.
And Cole question mark, give Ash.
Yeah, she meant to say 5 ash there, but I knew what she meant, I think.
But does that later get clarified?
That later gets clarified, yes. So, yeah. So there's clarification.
Because she's asking you, at what time is she asking you whose birthday?
That says 10:10 p.m.
And then it looks like she shares with you or sends you some sort of Facebook link.
Yes, but I don't recall what the link was.
And you remember the time that she sent that Facebook link to you?
I do remember getting it. Obviously, it says 11 p.m. there, 11:01 p.m.
11:01 p.m. And then you don't respond to her after the 11:01 p.m. text until the next day,
Right.
March 8th. And you tell her, mother, no, my friend Cole, I went to his wedding in Mexico.
Right.
The ATL Foodies people.
Yeah, the ATL Foods people, but yeah.
And what time was that message at?
7:25 a.m.
When you text your mom, would it be unusual to not get a response for hours on end?
It would be pretty unusual.
Is that why you send a text at 2:46 just with mother question mark on March 8th, 2025?
It is, because that morning I had gone to play pickleball and then came back and hadn't heard from her yet. So I sent that after lunch.
All right, thank you. Those are all my questions.
Hey, McLean, I just have a few questions. I just wanted to put back up some of the defense exhibits. So this is, we'll do defense 78. Let's see if I get this right. Oh, here we go. So this is defense 78. I'm going to zoom out so you can see it a little bit better. So this was the pantry, correct?
Correct.
And there are like drawers here, correct?
There are.
And then, this isn't a great view, but this is defense 79. There's also like cabinets and then some drawers over here, correct?
There are cabinets over there, yeah.
Are you familiar if someone says like, I have a junk drawer in my house?
I'm familiar.
So just kind of like a drawer where you just throw all the stuff you don't really know what to do with and you put it in a drawer.
Sure.
Correct.
Sure.
Do you know what was in any of these drawers?
I can't recall what were in the drawers on the left.
And these?
I can't recall what were in those drawers, no.
How about like the cabinets and stuff over here? Do you know what was in those?
Yes, I do.
What was in those?
There's a Swiffer jet in there.
Okay.
Swiffer jet fluid. There's a lot of cleaning supplies.
And then like defense is 77. You get just like a little bit better. There's like the drawers up here and then there's also like cabinets down there, right?
Right. I think those are just cabinets, yeah.
Yeah. And you have no idea what's in any of those drawers, correct?
I can't recall what's in them.
Okay. Did you know, you mentioned the Christmas party that you were all at. Sorry, microphone, give me 1 sec. You mentioned the Christmas party that you were all at. Were you, I honestly just, I don't know if you mentioned it, so I apologize if you did. Were you already living in the house at that point?
I was not living at the house at that point.
When did you move in?
I moved in on, I guess you could say, January 2nd.
So right after the new year?
Right after the new year, yeah.
So you were there for Christmas Eve was when the Christmas party was, and then I think you said you left the day after Christmas and then moved in on the 2nd?
Correct.
Did your mom tell you about the Christmas basket she got from the neighbors next door on the 28th?
I did remember seeing a basket, but I don't remember really much about it.
Did she tell you about how there was a nice note in it that gave them their names and welcome to the neighborhood and their address?
There was a basket, but I never talked to my mom about the basket.
Okay. And I want to show you, when you were living at the lake house, you were unemployed, correct?
I was employed like maybe days before the move-in or days right after the move-in.
Well, David was helping you find a job, was he not?
I would not say he was helping me find a job, no.
No?
That's not accurate.
I'm going to show you what's been marked. What are we at, Naz?
I believe we're at 270.
I'll double this. Are you sure? Are you sure? 270?
I believe we're
Okay. Oh, wait.
That's 270, 275, I believe 276.
I'm going to show you states 276. Do you recognize this text exchange?
I do recognize this exchange.
Is this a text exchange between you and your mom?
Yes.
Judge, I move to tender states 276 into evidence.
No objection. Admitted.
Judge, if I could have the screen again. So this was sent on in December of 2024. You said, is this you saying thank you, mother?
That's me.
You said, thank you, mother. Geez, wowzers, I love you. I will keep you updated with what happens with the job. Love you, right?
Still me, yes.
And then she says, spend wisely. I want you to relax. You are wonderful, smart, handsome, the best and kindest human being I know. David thinks so highly of you. He is always available to talk, correct?
This is correct, yeah.
And then you said, I am, mother. I love you. Thankful you have David in your life, correct?
Correct.
Thank you. I don't have any other questions.
No further questions.
Thank you for your testimony. You remain in the gallery. Thank you. You're excused.
Mary Madden Bishop.
Welcome. Come on down. You'll be over here.
Before you take a seat, if you'll step up there and raise your right hand. Do you swear or affirm that the testimony you're about to provide this court and the matter pending before it shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Thank you so much. You can have a seat. Use your microphone, please, and then state your full legal name. Thank you.
What's your full legal name?
Mary Madden Bishop.
And how do you know Suzanne Mericle?
She's my mom.
I want to sort of jump right into it, okay?
Okay.
And talk to you about the first time that you ever met Mr. David Barron,
Okay.
okay? Do you remember where you were when that happened?
I was in Birmingham, Alabama. That is where I currently reside.
Okay. How long have you been living in Birmingham?
About 2 years, 2.5.
Okay.
I went to Auburn University, and then I moved to Birmingham.
Okay. Was this the first time your mom had ever been to Birmingham?
It is not.
But was this the first time, I guess, your mom and Mr. Barron had ever been to Birmingham?
Correct.
Also served as the first time that you're meeting Mr. Barron, at least in person?
Yes, sir.
Okay. Let's just talk generally, and then we'll sort of get a little bit more into the specifics. What was the plan that weekend?
The plan was for my mom and David to come to Birmingham and for us to meet, go to dinner. I think we went furniture shopping, just to hang out and just get to know one another.
Do you remember, did they come in on a Thursday, Friday, Saturday? When did they come in?
Friday.
Friday, okay. And were they staying with you or somewhere else?
They were staying in a hotel.
Okay. A hotel in Birmingham?
Yes, sir.
Okay. The first time that you actually lay eyes on Mr. Barron? Is this at your house, the hotel, somewhere else?
It's at a restaurant called Batola in Birmingham.
Batola?
Yes.
Okay. Was there any particular reason to go to that restaurant, or?
It's one of my boyfriend and I's favorite restaurants, so that's where we chose.
Okay. So it's the two of you that travel from your house to the restaurant?
Yes, sir, we Ubered.
Okay. And then, obviously, your mom and Mr. Barron arrive?
Yes.
Was there anything remarkable that stood out to you in sort of the initial, immediate interaction?
Yes.
What was that?
What my mom was wearing.
Can you describe for the jury in a little bit more detail about what that was?
Yes. It was a tight, almost bodycon dress, sleeveless, turtleneck, very snug on her body.
Okay. Why did this stand out to you?
Because that is not something my mom would ever wear.
Did you get an understanding about where that dress came from?
Yes. She said, because I asked, what are you wearing? And she said, David bought it for me. Don't you like it? And I replied, no. And then she said, oh. And that's
Have you
kind
ever
of,
seen your mom wear anything like that?
I have not. It was very shocking.
How many social occasions, parties, graduations, dinners, family gatherings, holidays do you think that you've spent with your mother where she had an opportunity or an occasion to dress up?
Well, I've spent every Christmas with her, so 24, 23 Christmases, 24 birthdays. Dinners we went to a lot, especially in college. There's a lot of options, or many times that she could have.
And this is the first time that you've ever seen her in a piece of clothing like this?
Correct.
How was dinner?
Dinner was fine.
Okay.
It was just dinner.
Seemed like everybody had a good time. About how long do you think that you were at the restaurant with everybody?
Maybe like 2-ish hours.
Okay. Walk the jury through sort of the end of the night, the bill's coming, the bill is being paid, what's going on sort of in this moment in time.
So the bill is being paid. My mom paid the bill, which I thought was odd. And then my boyfriend and I, like I said, we Ubered, and my mom and David drove. And I asked my mom if she could Uber, or if she could drive us back to my house, which was 10-ish minutes away from the restaurant. And she first said yes, and then said no after, and said, David said no.
So how far was your house from the restaurant?
10-ish minutes, give or take.
Do you remember where they were staying in Birmingham, the hotel?
I believe it was in downtown Birmingham hotel.
So do you remember the area that they were staying in?
Yes, sir.
Okay. To get from the restaurant to your house, how much of an inconvenience or out of the way would that have been?
Maybe like 5 minutes out of the way.
And I think I heard, so your mom had indicated, sure, we'll drive you, right?
Yes.
Okay. But David wouldn't let her.
Correct.
When was the next time visited Birmingham?
Thanksgiving, which was my birthday.
Thanksgiving in what year?
2024.
Okay, so your birthday in the year 2024, did it fall on
It
Thanksgiving?
fell on Thanksgiving Day.
When did they get to Birmingham for this trip?
Like 6 p.m. on Thanksgiving Day.
Okay. And what did you guys do for?
We went out to a restaurant to eat Thanksgiving food and celebrate my birthday.
Okay. Were there any other plans to celebrate your birthday this weekend or this Thanksgiving holiday?
Yes, we had a birthday celebration at my house that following Friday, and they were coming.
This was being hosted at your house?
Yes, sir.
And who all was invited? Who all attended?
All of my family and friends, my family that were in town, like my brother and my mom, and all my friends that live in Birmingham. And I shared that party with one of my other friends, and her parents were also invited.
Were these friends that you had made when you were growing up in St. Simon's, going to school at Auburn, moving to Birmingham? Where are these friends coming from?
A mixture of college and Birmingham.
Talk to me a little bit about, just in general, how your mom would be in a setting with you and your friends.
She was always involved in their life, wanted to know what was up, what was going on. She was very friendly with all my friends. They all loved when she came to town.
Okay. What would happen when she came to town?
She would always take us to dinner, and then we would always just hang out. It was.
Did it seem like she was sort of invested in what was going on in their lives?
Absolutely.
And would she come to town sort of regularly?
Yes.
Did it seem like she was invested to the point where she would make it a point to sort of ask for updates?
Absolutely.
Based on the last time she had seen?
Yes.
Okay. So this was not just, your mom, not just somebody who sort of kept to themselves?
Correct. She never kept, she just wanted to know what my friends were up to, what was going on in their lives. She was like a second mother to a lot of them.
This birthday party that you threw or was hosted for you in the Friday after Thanksgiving 2024.
Correct.
Your mom and Mr. Barron were there.
Correct.
What stands out to you as maybe out of the ordinary or odd about that birthday party?
They stayed in the living room the entire time, which was very odd. I live in an old house in Birmingham where it's separated by walls, so it's not an open floor plan. And so,
not a house where like kitchen leads into dining room.
Correct.
And the living room.
Correct.
And the laundry room.
If you're in the kitchen, you're not going to see who's in the living room. And if you're in the living room, you're not going to see who's in the dining room or wherever.
What was unusual about your mom just sort of staying in one room?
She stayed there and sat there with David and didn't mingle upon my friends and I.
Is that the first time you'd ever seen your mom behave in that way in a social setting with your friends?
Yes.
Now, did you ever have an opportunity to travel to 4238 Bay Ridge Drive?
I did.
Okay. When was that?
Christmas. I believe it was the day before Christmas Eve.
Of?
2024.
Okay. How'd that trip go?
It was not great, if I'm being honest.
When you say it's not great, what is it about that trip that makes you feel like it wasn't great?
It was awkward. David was highly intoxicated the entire time, fell asleep at the table while we were playing a board game, then proceeded to get up, fill his cup some more.
Was this the first time that all three siblings had been together with your mom, spending time with her and Mr. Barron?
Yes.
How long were you supposed to stay?
We were going to leave on Christmas Day, mid-afternoon,
Okay.
to go visit my boyfriend's family.
Gotcha. Okay. The next time that you saw your mom and Mr. Barron after the Christmas trip was where?
On St. Simon's Island, where I'm from, and it was for New Year's Eve.
Okay. When did you get down to St. Because if you were in Gainesville for Christmas,
And then we traveled back to Birmingham, and then my friend group from Birmingham, we all went to St. Simon's for New Year's Eve, and we arrived, I believe it was the 28th of December.
okay. So you guys get down there on the 28th,
Correct.
December 28th of 2024 is when you guys arrived. When were your mom and Mr. Barron get down there?
I saw them the night of the 30th.
Okay. So you get down there again on December 28th of 2024. And then less than 48 hours later, you see Mr. Barron and your mom on St. Simon's Island.
Correct.
And was the purpose of that trip so that they could spend New Year's Eve together?
Correct.
How often did you text with your mom?
Every day. Multiple times a day.
Was it just sort of like a running conversation?
Mostly, yes. She always texts me good morning and good night every single day.
Did it matter whether you were at school at Auburn, working in Birmingham, traveling,
It did not matter, no matter what.
texting
I was going to hear from my mom
every day?
every day. Am I allowed to drink one of these waters?
You are.
Thank you.
I'm going to hand you some documents. Take your time, okay? Go through them, all of them. Let me know when you're done. You recognize what's in these documents?
Yes, sir.
Okay. What's in these documents?
Messages between my mom and I.
These messages starting on March 6th of 2025, going into March 7th of 2025?
Yes, sir.
And do these truly and accurately reflect the conversation you had via text with your mother on those dates?
Yes, they do.
Judge, at this time, I would move to admit Defendant's Exhibit 75.
Judge, I haven't been objecting to any of the evidence, but these I genuinely don't see how they're relevant. So I would object as to relevance of these messages.
And Judge, these go to, they're relevant because they establish a timeline on the day that Ms. Mericle is traveling from St. Simons to 4238 Bay Ridge Drive for the last time, and then on the March 7th, which we all know is the day that leads into the early morning hours of March 8th.
Overruled for purposes of relevance. I'll take objections as they come if there's anything else, but it's admitted.
Thank you, Judge. And if I could have the Elmo for one last time. Okay. On March 7th, 2025, at 10:46 in the morning, what do you text your mom?
My ear hurts so bad.
And you follow that up with what?
What do I do?
What was your mom's advice?
To go to the urgent care, and she asked if I had an ENT.
And you tell her,
I really don't want to go to the urgent care.
because
$50 copay. Wild. She says, haha.
and then asks,
Where are you? To make sure that I went.
what do you tell her?
Would have been 100 at urgent care because I ended up going to my PCP.
Tell you.
Adulting is hard.
I think this is what you're talking about, telling her that.
At my general doctor. She replies, good. And I said more like adulting sex. Not hard.
And it looks like, did your doctor call you in anything?
She called me an amoxicillin. I could have saved $50 if you would have done that.
And that's at 12:54 p.m. on March 7th, 2025? She then reaches out to you. Can you see what time she reached out to you?
Did it say 6:43 or 4:06?
There you go.
Oh, 4:06 and 43 seconds, maybe.
She asks you how your ear is,
Correct.
and you tell her,
Hurts. Very bad. And she replies, I am sorry. Do you have Tylenol and ibuprofen? Do you have a heating pad? And I say, I've been doing all of that. She says, it's probably going to take 24 hours. How many antibiotics have you taken? I said, 1. She said, take another. I replied, okay. She said, take 4 today. I said, wow. She said, that is not a lot. Take a nap. It'll make you feel better. I said, it told me to take 1 every 7 hours. And I said, I'm working, I cannot nap. She says, is it amoxicillin 500 milligram? And I said, let me check. I hope so, because I did what you told me.
Is that in reference to taking more?
Taking more. And she said, did you decide to go out for dinner with your friends?
What time does she text you asking about going out to dinner with your friends?
8:29 p.m. Yes, I'm here. Still in pain. Trying not to think about it. When is the last time you took Tylenol? Advil? An hour ago. Are you taking the Advil and the Tylenol together? No. I just have Advil. No Tylenol. She says, do you have Tylenol extra strength, 500 milligram?
What time is that message at?
8:55 p.m.
On March 7th, 2025?
Correct. I replied, no. Stop and get some Tylenol extra strength. Maybe someone there has it, and every 6 hours you take 2 Tylenol, 500 milligram, and 2 Advil, 200 milligram, 4 tabs at once, and it'll make you feel better. I replied, okay. She says, love you. I said, love you more.
And she sends you a message not about medication. What time does she send you this message?
At 9:07 p.m.
And what does she ask?
Have you decorated for Easter yet? Do you have things? I replied, I have a few bunnies, but want to get some more. Trying not to spend money right now so I can pay off my credit card bill. She replied, me too. I think that was referencing the bunnies part. I don't know what it was referencing. She said, I sent you 2 of these, and it was 2 wicker bunnies.
And what time does she tell you she's sending you those?
9:29 p.m. on March 7th. And I replied, OMG, I love those.
And then you send her this last message when?
March 8th, 2025 at 2:16 p.m.
Had you heard from your mom that day, March 8th, 2025?
I had not.
And was that unusual?
It was.
Was this message sort of sent out of concern?
Yes.
Those are my questions. Thank you.
Thank you.
No questions.
Thank you for your testimony. You remain in the gallery.
Thank you.
Defense rest. Defense rest.
Defense rests.
Judge State has rebuttal evidence.
And maybe you approach briefly on that.
How brief?
3 minutes? Maybe 5.
Members of the jury, I'll see you back at 3:10, please. 3:10. Thank you. Y'all can sit, stand, I'm fine. What do you have? What do you have?
I was I was under the impression the state was going to be presenting some character evidence of the deceased, and so I had a conversation with Ms. Bennett about that. My concern was we were going to get that they might mistakenly get into specific instances of conduct or questions about has he ever, and Ms. Bennett has assured me that this is merely going to be opinion evidence about peacefulness. And so if that is the limitation, if that is what they present, we don't have any objection to that presentation, as long as it's done as general reputation for peacefulness and not specific instances. So I thought we were going to have an argument, but she's on the same sheet of music as me, so I was a lot shorter than the 5 minutes I told the court. Sorry.
And just so everyone's aware, I've informed both witnesses as to what they can and can't discuss. We're not getting into specific acts of good conduct, simply just the question of were you able to formulate an opinion as to his character for peacefulness, and basically just so we're all on the same page, make sure we don't violate anything. I've informed them. Obviously, we're not getting into he's never done this, he's never done that, things like that. Adjectives that they might have to describe their opinion as to his character for peacefulness, I think is very general, nothing specific, and that's the only thing we're doing.
Okay, thank you.
That's it.
Anything else?
No, Your Honor.
Yes, back at 3:10, and bless you. I would anticipate that these witnesses won't be super long.
No, Your Honor.
Be done by 3:15, 3:20, Judge.
Yeah, they'll be very quick.
Okay. Thank you.
Thank you, Judge.
Brief recess.
I'm gonna go use the restroom.
Ms. Bennett.
Where was that stapler you were using earlier?
Llewellyn.
Yeah, you need some?
Turn around, Ms. Mericle. Llewellyn. Door.
I didn't know where it was. I can't really see well.
Yeah, I know. It's really.
Good? Yes, sir.
All right, let's bring it back. All right, thank you so much. Y'all can be seated. Welcome back. Appreciate your patience. Defense has rested, and the state has an opportunity to present additional evidence called rebuttal. This is obviously a very real case. This is the way you do it in the real world. State.
State recalls Beth Barron to the stand.
Come on up. Welcome back. You've been previously sworn. Thank you.
So you, I want to kind of recap a little bit. When did you meet Mr. Barron?
I met David in college. It was 77.
So 1977.
1977, yeah.
And then you dated for how many years before you were married?
We dated about 2 years.
And then you were married for 23 years?
22 years.
22 years. So at this point, how many years have you known David? Had you known David?
About 50.
And we talked a little bit about it before. After you and David divorced, did you remain friends with him?
I did.
how would you describe your relationship with him after? Like, were you close? Did you just kind of say hello on holidays? Like, what was that relationship like?
We talked often, and we usually talked about the kids and the events that we were about to have, and we just had a good relationship, a friendly, good relationship.
And in the 50 years that you were friends or married to David, were you able to formulate an opinion as to his character for peacefulness?
Absolutely.
What is your opinion as to his character for peacefulness?
David is probably the kindest, sweetest man that I've ever known.
Objection as to the response form. Improper opinion evidence has to be character for peacefulness and stated as such. Object to the response.
So I don't really believe that her response was improper, Judge.
Hold on. I appreciate the timely objection. Let's rephrase and I'll hear the answer. Go ahead.
Do you have an opinion as to his character for peacefulness?
David was a very peaceful, calm, loving man.
Thank you. I don't have any other questions.
No questions. Thank you.
Thank you.
Thank you for your testimony. You can return to the gallery.
Thank you.
And then the state calls Laura Anthony Phillips.
All right, welcome. You'll make your way up this way. Thank you so much.
And ma'am, if you wouldn't mind, when you get up to that chair, if you could raise your right hand. Do you swear or affirm the testimony you'll give the court is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can take a seat. Would you go ahead and state your name?
Laura Anthony Phillips.
And how did you know, or did you know David Barron?
Yes.
How did you know him?
I dated him for 3 years, lived with him for 3 years, and then we were married for almost 10.
So when you say you dated for 3 years, when did you first meet him?
End of 2001 into 2002.
And then you dated for a couple years. At what point did you move in with him?
He moved in with me, I believe, end of 2003 into 2004.
And then what year did you end up getting married?
2004, July.
And then you were married for almost 10 years, you said?
Yes.
Once you and David got divorced, did you stay in contact with him at all?
Yes.
Tell me about that. Like, what did you just speak every once in a while? Did you remain in good contact with him?
We kept in contact in regards to texting happy birthday on his birthday, just checking up on him, see how he was doing. And in return, he would do the same for me, wishing me a happy birthday.
Would you say that you and David were friends after you got divorced, or would you say you were more just like acquaintances after you got divorced?
We were friends.
Were you friends all the way up until the day that he was killed? Like, was there ever a point prior to his death where you had stopped being friends with him?
We didn't have any contact. My birthday is on February 19th, and normally he texts me on my birthday to wish me a happy birthday. And then in return, I do the same on his birthday and just kind of catch up and see how he was doing or how I was doing and about the family and the grandchildren and whatnot.
And so on February 19th of 2020, you said February 19th, correct?
Correct.
Okay. Of 2025, did you hear from David on your birthday?
No.
Had you not heard from him on your birthday before, or was that the first time you had ever not heard from him on your birthday?
That was first time.
First time.
That I have not heard from him.
So in total, I guess it sounds like you've known him, you met in '01, he died in '25. So for that 24 years that you knew Mr. Barron, were you able to formulate an opinion as to his character for peacefulness?
Yes.
And what is that opinion?
I find David to be a caring.
Objection as to the response. Opinion as to peacefulness.
And I'll ask it again. Did you formulate an opinion specifically as his character for peacefulness?
Yes.
And what is that opinion?
My opinion is he is caring.
Judge, same
He's
objection.
kind.
Same objection. May the witness be instructed. I thought we discussed this.
And I thought that I had explained exactly what I told for the witnesses to do, and I think that's exactly what she's doing.
Overruled.
You can continue.
Yes. So he's very caring, kind, respectful, very honest.
Judge, I have the same objection. This is way outside.
So do you...
Same objection. I have a ruling on the objection. And I move to strike.
Okay, I'm trying to give you a ruling. We're going to sustain your objection. Ask the question one more time, please.
Did you have an opinion specifically as to his character for being a peaceful person or not? Like, do you have an opinion as to whether or not he was a peaceful person?
Absolutely.
And what is that opinion specifically as to peacefulness?
He's a very gentle, kind man, an honest man, and a patient man.
I have the same objection as before.
We're going to end it there. Anything else?
No other questions, Judge.
All right. So for the record, the objections overruled. Any questions for the witness?
No, sir. Thank you.
All right. Thank you for your testimony. You can go in the gallery or go about your business. I'm fine either way. Thank you.
State has no other rebuttal evidence, Judge.
All right, folks, very appreciative of your time. You certainly given a lot to your community, and we very much appreciate that. The next stage will not occur this evening, but the next stage is closing arguments. I have no idea how long they're going to be. But typically, it's a bracket of 2 to 4 hours, so you can do the math. If we were to do it now, we'd probably be here till about 7:30, 8 o'clock, and then I'm going to read to you approximately 25 to 30 minutes of the law as it relates to this case. I need to speak with the lawyers, and we did some of that last night. I need to speak with the lawyers again about what I read to y'all. So there's no point in us going till 9 o'clock tonight. So we're going to release you today, come back at 9, and we're going to start with closing arguments. I would like to start punctually at 9, so I'm going to tell you some things that I would tell you then, I'll tell you now. You may be familiar with other types of closing arguments. This is a real case. Typically, the state will give a introductory closing argument, and then sandwiched in between, the defense will go, and then the state will go again. That is common practice in Georgia. So you're likely going to hear from the state at first, and I'm not telling you how long they're going to be, but roughly 30, 45 minutes, roughly. And then the defense will go, and then the state will come back, and then I will read you jury instructions, and then you'll be released to deliberate. The evidence in this matter is concluded. All that remains is argument from the attorneys. Appreciate your patience. As always, do not discuss this case with anyone. Do not perform any research. Do not go to the scene. Do not go online, paper, books, AI, none of that stuff. With that, thank you for your time. We'll see you back tomorrow morning, 8:45, 9 o'clock. Thank you. Thank you. We'll rotate to charge conference in a moment.
And just why we're moving for a directed verdict, Judge. And we have a brief in support of that, which Mr. Bullard has prepared, and we'll be handing copies to the court and to the state. It is in support of our motion for directed verdict.
So we'll be, y'all can sit, stand, wherever you want to do. I have no idea how long this is going to be. If I had to guess, I would say a half hour plus or minus. So we're going to conduct a legal motion. Again, I'm not putting any limit on anyone, but I anticipate this could be a half hour. Obviously, sometimes I'm wildly wrong, and it could be 5 minutes or it could be 2 hours. We just had a break, so I'm not inclined to do another break, so we'll roll right into legal matters up to and including any additional from the defense, any additional from the state, and then we will rotate into charge conference as well as some administrative issues that we probably need to address. Defense, floor is yours.
Your Honor, may I approach the brief?
Thank you.
Judge, I'm confused. We've already had a directed verdict argument. It's already been denied. This is, we've already argued a directed verdict at the close of the state's case in chief. The defense has already had their opportunity to argue a directed verdict, and Your Honor's already given a ruling on a directed verdict. I don't understand why we are now having this argument after the defense's case in chief.
Your Honor, if I could point the court to page 2 of the memo, where we deal with an anticipated objection that we did not raise these specific grounds earlier. OCGA 1791 says that we may move for a directed verdict. Sorry,
it's not your fault.
All right.
Everyone's working, and I appreciate that. Go ahead.
Either at the close of the state's case in chief, or, but since it's cast in the disjunctive, there's no reason we can't do both. In addition, a motion for directed verdict in Georgia is essentially a challenge to the legal sufficiency of the evidence, which is not something that as a constitutional matter can be waived. It can be raised at any time that it is ripe, and it is ripe right now. So it is not that we were entirely allowed to defer this, to wait until the close of the evidence to see what all of the evidence was.
Procedurally, I think you're correct. I'll hear from the state. If you want to take a break, that's fine too, but I do believe procedurally you are correct. Making no comment one way or the other on the substantive portion of it.
I mean, it says or, it doesn't say and or. It says that they can move for a directed verdict at the close of the state's case in chief or later if they fail to do it before. It doesn't say both. You get to just continue to do it.
Your Honor, often in statutes, when things are cast in the disjunctive, it means they are in the, not only in the alternative, but it means that we can do both. I would point out that the state, as a matter of sort of opposite points, the statute dealing with when the state may open and close. It says the state may open and close, and the state often waives their first opening. The fact that it's or does not mean we can't do it at this time. It's not a waiver issue. We have long since done away with waiver issues on motions, on on directed verdict motions, that you don't waive it by not raising it earlier, that you defer it, that it can be deferred. There's no reason we can't raise these issues now. What's more, since it is a sufficiency argument, the court could hear it at the motion for a new trial and still strike the matter. In fact, it's in the interest of judicial economy that we go ahead and resolve these questions now. So the court is entirely within its power to grant a directed verdict at this point, and we're providing the information to the court for it to do so. And there's absolutely, there really is, I really don't understand Ms. Bennett's argument simply because we have the option of doing it at one or the other does not mean we can't do it at both.
Well, I imagine that you do understand her argument, you may disagree with it. So, all right, if the state wants to address it later, that's fine. As of right now, I'll authorize it. Go ahead.
Thank you. Your Honor, I'm not going to talk about...
To be clear, procedurally, go ahead.
I understand, Your Honor. I'm not going to talk about every count in the indictment. We're going to submit entirely to the court's discretion without argument. What I would like to talk about are specific issues within counts 2 to 5. I want to look at those in two groups. All right.
Go ahead.
First, I want to take the first group are those counts related to or that are predicated on aggravated assault, which would be counts 2, count 4, which is the aggravated assault charge itself, and count 6, which is the possession of a firearm during the commission of that aggravated assault in count 4. The second group will be the counts dealing with the criminal damage, so the odd counts, the count 3, which is the felony murder predicated on criminal damage, and on count 5, the criminal damage itself. Our argument as to, and I'll say in no case, as to those counts, are we asking for the court to strike the counts in their entirety. But 1791 authorizes the court to grant partial relief, to allow the case to go to the jury on lesser offenses. And that's what we're talking about here. Actually technical matters of proof. So, we have been talking since before the beginning of the trial as to the aggravated assault counts, that there are two species of assault. The Supreme Court has said repeatedly that an aggravated assault is some form of simple assault plus an aggravating factor. I know we've been talking about it. It raised its head yesterday in the charge conference. We brought it up at the demur, and it's relevant here. The law is clear that an A1 assault, the attempt to commit a violent injury assault is a specific intent assault plus the act that is attempting to commit a violent injury. So basically an attempted but inchoate battery. The A2 assault is a general intent crime. It requires one to intend to act in the assaultive manner. And this is where we draw our line in the sand, that the victim be shown to have reasonably apprehended the assault. As to the assault counts, we are asking that they go to the jury on nothing more than an attempted injury species of assault. We do not believe that the state has provided sufficient evidence for the jury to infer that Mr. Barron anticipated the shot that killed him. And I know, I can feel it behind me. There's some tension here because he did get hit. He absolutely got hit and he was killed, but the striking and killing is not the anticipation, as the Court of Appeals made clear in Montford versus the state. Montford is cited in our motion at 254 Georgia Appeals 524. What's interesting about Montford is that both species of assault were in play. It was an aggravated assault case, aggravated assault against a law enforcement officer. The undisputed evidence is that the defendant, Montford, struck an officer. The undisputed testimony was that the defendant, Montford, was not, looked up and did not realize until the last moment that there was a car in front of him. So the undisputed evidence was that he did not have the specific intent to commit the assaultive act, which ruled out the A1 assault. The officer, the victim's testimony was that he did not perceive the assault, he did not perceive the car until he was hit. So it is the apprehension that is the essential element. Here, we have a shot passing through the door. That's what's in the indictment, that's what the evidence was. We have a shot passing through an opaque, can't see through it, door. And the undisputed evidence shown in by Dr. Zhang and Investigator Durham's display, I think it states 181, if I may. Just for sake of using the OMO, if I may. Make sure I've got this. The shot, Your Honor, comes through the door, through the wall, and into Mr. Barron's left side. If that is his left side, he is facing away from the direction of the shot. So we do not have visual perception of the shot. I'm going to put this back. So that leaves us with oral perception of the shot. The court can take judicial notice that the speed of sound at sea level is 1,225 feet per second, 1,225.538 feet per second. Your Honor, the bullet leaves the end of the Glock faster than the speed of sound, and it travels an incredibly short distance. Dr. Zhang, when asked, said she couldn't say whether Mr. Barron would have perceived the shot beforehand, but the evidence came in under Rule 613 that she told Mr. Willis previously that she didn't think he would have. It is absolutely too short a distance for Mr. Barron for the sound waves from the end of the gun to have hit the tympanic membrane of Mr. Barron's ear prior to the shots colliding with him. I know these are matters of technical proof, and I know it's probably dissatisfying to the audience for me to say it, but the bottom line is the law is the law. And Mr. Barron could not have reasonably apprehended the shot, and so we object to counts 2, 4, and 6 going to the jury on an A2 assault theory, leaving only the A1 intent to injure assault. We leave it to the court whether there is sufficient evidence for them to go to the jury on the intent to injure species of assault. But as to the A2 species of assault, the evidence, there's just simply no evidence from which the jury could infer Mr. Barron's reasonable apprehension. Secondly, I want to talk about counts. I'd like to talk about counts 3 and 5. Count 3, Your Honor, is the felony murder predicated on the criminal damage, and count 5 is the criminal damage itself. The elements of criminal damage under 16722B are knowingly and without authority interfering with any property and recklessly and thereby endangering human life. I don't remember how the end of the phrase is exactly said, but the point here is knowingly and without authority. Under Scott versus State, again, which is cited in our brief, when the General Assembly puts knowingly in a statute, it means that the state has the burden of proving beyond a reasonable doubt that the defendant is aware of the facts that would make her conduct unlawful. Here, and I know we talked about this a little yesterday at our preliminary charge conference, there is no dispute that Mrs. Barron was an owner of the property and thus the door inside of it, and a person has broad authority to dispose of their property as they see fit, including damaging it. And so I know, and I mentioned Gooch versus State to the court yesterday, which is sort of the closest case on point. It was a Court of Appeals case dealing with first-degree criminal damage to property. And the issue in Gooch, or the facts in Gooch, which arose actually out of Dawson County, were that the defendant Gooch and his ex-wife were in an argument and they were fighting over a quilt, a blanket. The blanket was set fire to, the defendant set fire to the blanket, tossed it down, and the ex-wife had to jump over the blanket so as to avoid getting burned. The issue raised in that case was whether simply the fact that the defendant had claimed a property right in the blanket was sufficient to defeat a first-degree criminal damage charge. There was no discussion in that case of the scope of his legal authority. As for that case, what the Court of Appeals said, the Court of Appeals said two things. One, whether he has ownership of property, it is not an automatic defense on the facts of that case to the charge that he had an ownership interest, and arguably had an ownership interest in the property. The Court of Appeals also notes in Gooch that that there was evidence that even if he had asserted it, the jury could have found that he did not have an ownership interest because the wife claimed that the blanket was given to her outside of the marriage, and so it was not marital property. The problem the Court of Appeals had is that there is no property of another element in first-degree criminal damage as there is in second-degree criminal damage. Both offenses, I would note, derive from the former charge that persisted up to the 1960s of malicious mischief. And all cases of malicious mischief required property of another. That element was not carried forward expressly into the first-degree criminal damage charge. But questions of authority under 1613, paragraph 18, are if one is without authority, it means that one is not, or one is doing something that they do not have the legal right to do. And if one is knowingly without authority, it means they must be aware of the fact that they do not have the legal right to do it. So for one thing, a co-tenant in a home, and I feel the co-tenancy argument bubbling up behind me. A co-tenant in a home has full and equal rights to enjoy, profit from, alienate, dispose of their share, their total share of the whole, without the objection, without the permission of their co-tenant. And so what we're talking about here is the interference with property that is claimed to be without authority is a bullet hole. It's remarkably small and really does not largely change the value of the door or the value of the house. So for a person to not have the authority to damage their home if they have a co-tenant, it means that anytime my wife, actually I'm more likely to be the one who accidentally breaks something. If I break something, am I accountable to my wife? If I share a home with a person who is not my spouse, am I accountable for damages, for minor damage? If I did not ask permission before I did some damage to the property? The test, Your Honor, is a question of waste. A co-tenant might be able to collect in damages for waste, but waste as a matter of law is something that diminishes the essential value of the realty. And that's what we're talking about here, realty. Not just a blanket, but we're talking about a home, which is part of the realty. Or something that defeats sort of the future inheritability. And I'll say the cases on this are all old. We haven't had a real discussion in Georgia law of what the meaning of waste was since the early 1900s. But point the court, and I regrettably did not include this one in our memorandum, but I point the court to Roby versus Newton. That's 121 Georgia 679, 1905, where we discuss what the common law of waste is in Georgia and what will become the meaning of waste under 44-6-121A, which discusses the rights and obligations of co-tenants in property. The meaning of waste is some damage that destroys the essential value, the inheritability of the future state, not minor damage, not something that can be repaired easily. So for example, and this is old, but for one of the examples the court gives in Roby is that at English law, and I know everybody's groaning about to quote English law, but at English law, a co-tenant could not clear the field of a jointly owned piece of property, or a tenant cannot clear the field of a jointly owned piece of property because it was waste, because the landlord or the co-tenant, whomever also had an interest in the grain from the field, would have lost that value. In Georgia, that is not so because the field can grow back. It is only destroying the field. Distribution of mineral rights, if you take minerals out of the property, change the essential nature of the property. Shot in the door doesn't change anything, Your Honor, and there was no obligation. Ms. Mericle had a right to damage her own property, and no one had the right to tell her otherwise, and even if the court were to conclude that's not so, there's absolutely no evidence from which one would infer that she knew that fact. Because what we're asking people to do is anytime you're in the home, like, the contrary, unless there's some evidence, would be to think that, oh, well, whenever you're in the home, you know you can't dispose of it the way you want because you have to ask the co-tenant, your housemate, your spouse, whomever, permission for everything. That's not the law. When without authority is an element of a crime, as it is in, say, burglary, it must be proven by affirmative evidence, which is why in burglary cases you always ask did you give so-and-so permission to enter your building, enter your home, walk on your, whatever. The without authority has to be shown that way, because it cannot be inferred. We cannot infer a criminal defendant's intent, which includes the criminal defendant's scienter, the knowledge of the truth of the fact. And there's simply no information that would allow the jury to infer that Ms. Mericle knew she was without authority, even if the court were to find that she was without authority. And for that reason, the without authority element does not survive in counts 3 or 5. And the remaining elements, that she interfered with property in a manner that was dangerous to human life, amounts essentially to reckless conduct. And reckless conduct that is the proximate cause of death is involuntary manslaughter. And so we ask that the count 3 go to the jury only on a theory of involuntary manslaughter, and count 5 go to the jury on only a theory of reckless conduct. That's my argument.
Judge, I didn't really hear anything that we didn't already argue yesterday and was denied, or 2 days ago, whenever it was. As to the aggravated assault, this is now the 3rd or 4th time we've had to argue the same exact thing. Those all sound like great closing arguments for Mr. Willis. We're here for a directed verdict that there is some evidence of these counts. We're not here for a beyond a reasonable doubt. We're not here for a demur. The demur's already been denied. The first directed verdict about the same exact thing that was just argued's already been denied. As to the aggravated assault, I don't know how many more times we have to argue the same exact thing that the state can prove either one of the aggravated assaults. We do not have to pick if the defendant intended to injure or if the victim was in reasonable apprehension of receiving violent injury. It's either or. The jury gets to decide. That's already been talked about multiple times with this case. As far as the actual evidence, there has been an overwhelming amount of evidence that not only this defendant did intend to assault Mr. Barron, but he also was in reasonable apprehension with the fact that he was hiding behind a locked door behind a wall in a defensive stance, while the defendant, based off her own testimony, said, "I've got a gun too, David," is what she said about 5 times or more on the interview, as well as on the witness stand, when she continuously said that she told Mr. Barron she had a gun. He goes up and retreats to the bedroom, locks the door, and hides behind a wall. That is an overwhelming amount of evidence, not only that she intended to assault Mr. Barron, but also that he was in reasonable apprehension of receiving violent injury. I quite honestly, Judge, do not understand why we are continuing to argue the same thing over and over in the hopes that Your Honor is going to give a different ruling. I would ask Your Honor to maintain the same ruling that Your Honor has consistently maintained in denying that aspect of the directed verdict. Again, as to the criminal damage to property in the first degree, I don't really understand where the defense is going as far as their interpretation of Gooch. My interpretation of Gooch, as well as just the bare words in the statute, is that a person commits the offense of criminal damage to property in the first degree when she knowingly and without authority interferes with any property in a manner so as to endanger human life. There's so much case law. The majority of the time where criminal damage in the first degree is used is when someone has fired a gun at a building, at a door, at an apartment, at a car. It's always a bullet hole. Is like almost every case that I look up as far as criminal damage to property in the first degree involves a bullet hole through some sort of item that damages that item and it has endangered a human life. That's like the majority of the time where that charge is used. So to say that it's just a little tiny bullet hole, that's not the point of this statute. The point of the statute is that she knowingly interfered with that property. We know that she knowingly shot the door, and we know that it was without authority because it's very clear in Gooch that when it's shared property, that it's just, and in any event, marital or family property partially owned by another is sufficient to establish the commission of the offense under 16-723A1. And then it continues to talk about all of the things that make this okay. There's been more than enough evidence in this case to show that the defendant purposefully walked up to the door, got 6 inches away, aimed the gun, and intentionally fired the gun. It has also been more than well established that Mr. Barron and her owned the property together. It's no secret that they owned the property together. So she knows that she's not the sole owner of this home and what's in it. There's also been text messages admitted where she was threatening basically to have some other man come in and basically kick Mr. Barron out, and they have this full discussion. I'm on the deed. You can't do that without me. I've got a signed title over. There's been plenty of evidence to show that Ms. Mericle knew she was not the sole owner of this property as well as all the contents within it. Mr. Barron was, at this point, the main resident of this house. She was just visiting on the weekends. He lived there full time. This was his full-time residence. She was just visiting for the weekends. They owned it together. They helped pay the mortgage together, so they shared this property. But there's been plenty of evidence in this case to show that this defendant knew that she was without authority to do whatever she wants with this property. She damaged the property, and it was in a way that endangered human life because Mr. Barron is dead. So if Mr. Willis wants to get up and argue all those reasons why they should not find this defendant guilty beyond a reasonable doubt of these counts, obviously is more than capable of doing that. I know he's going to do a great job making all of those arguments to the jury. But as far as a directed verdict, Judge, we're not here for demur. We're not here to say that it's impossible for her to admit to this and it not be illegal because she didn't know without authority, all those things. We're not here for demur. We're here for a directed verdict for a second time, arguing the same thing, that she had the authority because she owned the property. I just genuinely, Judge, I don't want to repeat myself again and again and again, so I would ask Your Honor to deny the directed verdict. There has been more than enough evidence as to all the counts in the indictment, and I would ask for Your Honor to leave it up to the jury to make the decision as to guilt or innocence to the charges in the indictment.
Defense, last word.
Ms. Bennett's argument is largely unresponsive, Your Honor. These are questions of technical proof based on the averments and the elements of the statute. As to the aggravated assault, there's no averment of words. There's no averment of threats. The averment is shooting the door. It has to be shooting the door that provides the reasonable apprehension, not anything else. If the state had wanted to allege by shooting the door and threatening, etc., then it ought to have done so. As Ms. Bennett said, it really isn't the grand jury. She reminded us at the beginning of the trial that the charges are really just something she types up in her office. If Ms. Bennett wanted to allege more facts, she ought to have alleged more facts, but she didn't. The averment is shooting the door, and shooting the door in this case on these facts cannot be inferred to have provided Mr. Barron with any knowledge of anything. Now, as to whether this is the demurrer argument all over again, I'll admit it's related. But Your Honor, we've had to eat the fact that, that the court has allowed the state to go forward on two theories without specifying either. We're at this point, the state has gone forward on two theories without specifying either. What I'm saying, what the defense is saying, is that the state has failed as to one of those theories, and so only at best the other can survive. Now, as for the criminal damage case, I urge Your Honor to take it under advisement for 5 minutes. Gooch is short. Go read it. And I challenge Your Honor to find where the phrase "without authority" is discussed at all in that opinion. The only place in that opinion where it is mentioned is when the language of the statute is recited, but the discussion in that case is only about property of another without reference to the elements. And I'd like to point the court to one of our Supreme Court's favorite citations. In Georgia, it goes back to Albany Federal Savings and Loan Association versus Henderson, but the original source of the quote is Webster versus Fall. The Albany Federal Savings and Loans, 198 Georgia 116, and Webster versus Fall is 266 Georgia US 507. Questions which merely lurk in the record, neither brought to the attention of the court nor ruled upon, are not to be considered as having been so decided as to constitute precedents. Gooch does not control the facts and the law bearing on the question of what one has the authority to do with respect to their own realty is the law. So I urge the court to take it under advisement, look at Gooch, see if I'm wrong. Thank you.
Thank you. I'm not going to rule right now. Next. Y'all ready for charge conference?
Yes, Your Honor.
Third copy of the instructions, let me know.
Thank you. This is, okay, sorry.
You want a third copy?
No, we're good. Yeah. The judge. Judge, can we take the two firearms back into our office for the day? Yeah.
Yes.
Thank you, Your Honor.
Folks, you're more than welcome to stay. It's an open court. We're going to do a charge conference. It is not the most interesting thing, so if you want to leave, that's fine. If you want to remain, that's fine too.
No. No, just two, sorry.
Third copy. There you go.
All right, let's look at verdict form V2. You'll note that the verbiage of beyond a reasonable doubt has been removed. Some other tightening up or cleaning up. I know that the defense wanted a different order. I respect that request, but you'll note it does not reflect that request.
I'm not going to lodge an objection.
And may I remain seated for this portion, Judge?
Yes.
Thank you. Ms. Bagwell.
Did you
and
need to
I-
grab something? That's fine.
Ms. Bagwell and I discussed this last night and this morning, and at this point, I think that we would object to the voluntary manslaughter lesser included as to the felony murder based off of criminal damage to property.
I apologize. We're talking about the verdict form?
Yes.
Okay. Go ahead.
And I guess, I mean, it's also, I guess, relevant to jury instructions, but I was just thinking about.
We're
it 'cause
not
we were
there yet.
looking
That's
at
why-
the-
yeah.
At the verdict form, and I saw that, so I don't know if, do you want me to wait?
Well, is it a substantive issue or is it the
I guess
form?
it's a substantive issue, so we can wait until we get to instructions. I just thought about it because I saw it on the form and.
Well, you can keep going. I just want to make sure we're on the same page.
Okay, so I do not think that voluntary manslaughter is appropriate as to the criminal damage felony murder. The reason being is the point of voluntary manslaughter is basically to say that an individual, I mean, in this case, as it relates to the facts of the case, to say that Ms. Mericle shot the victim because she was overwhelmed with like the excitement of passion, essentially is what the purpose of voluntary manslaughter is. So saying she didn't have the malice to do what she did, she was just overwhelmed with this excitement of the passion is voluntary manslaughter. And as to the criminal damage, the intent isn't necessarily to injure, it's the intent to interfere with the property. And so to say that someone was so excited that they interfere with property doesn't really make any sense based off of the facts of the case. Voluntary manslaughter is appropriate for an aggravated assault. So the voluntary manslaughter charge is under circumstances that would otherwise be murder acted only because of sudden, violent, irresistible passion. So Ms. Mericle is not saying that she shot the door because of passion. She's saying she shot the door because she was trying to shoot the lock off. So it's a completely different intent as compared to aggravated assault, where we have to show there was the intent to assault. And then you can use the argument of she didn't intend to assault, she just was overwhelmed with this sudden, violent, irresistible passion. And so I do think voluntary manslaughter could be appropriate, lesser included as to the malice murder and the felony murder based off the aggravated assault. But I do not believe that based off of the intent required for the criminal damage, that voluntary manslaughter would be appropriate. Involuntary manslaughter is the appropriate lesser included because that goes more towards she did an act that was reckless. And so essentially it was reckless for her to try and shoot the lock off of the door, and as a result it endangered Mr. Barron's life. And so that's why involuntary manslaughter is the more appropriate lesser included for the felony murder based off of criminal damage, and not the voluntary manslaughter. They're two very different things. And so the state would object to voluntary manslaughter being given as a lesser included only as to count 3.
And on version 3, what page were you referencing?
Page 9
Thank you.
is the voluntary manslaughter charge. And then page 10 is the involuntary manslaughter charge.
in circumstances which would otherwise be murder, is the language of the statute. The court explained in Edge versus State in 261 Georgia 865 in 1992 is that to
261 Georgia
865 1992. Edge is the seminal case, but there are cases that flow from it. Is that to preserve voluntary manslaughter is a separate form of homicide. The question is whether the provocation or the passion due to provocation or is sufficient to mitigate the underlying action. Basically, is it part and parcel of the same assault? In Edge, it was an assault, but here what we have is, let's look at the facts, and it really is a fact-bound question. We know that Dr. Mericle was seeking to enter the room where David Barron was, and to the extent that the jury could find that she intentionally shot the door. So it's the reckless endangerment of human life, that she intentionally shot the door. It's still an intent that could be mitigated by the provocation or by provocation. And so the voluntary manslaughter charge is entirely appropriate as to all three murder counts. Yeah, I mean, and actually, just like it is for an A2 assault, Your Honor, like as we've been talking about, there's no specific intent required for that assault. It really is just an intent to act. And in here, there's an intent to act. We wouldn't dispute that there's an intent to act. The question is really whether it was without authority, which we've put to the court. And then if the intent to act, if the act done recklessly endangered human life, then that's the gravamen of the offense. But it is absolutely the type of offense that can be mitigated. The offenses that can't be mitigated, possession of a firearm by a convicted felon, where that's the predicate, that can't be mitigated. Gang activity, criminal gang activity, that's not the sort of thing that can be mitigated because there are elements sort of outside the act that make it a felony. But here, it's just another description. The state's looking for another description of the same act. And under those circumstances, it can absolutely be mitigated by provocation and passion. And we would submit that it is entirely appropriate to leave the charges as they are.
Okay, I've marked pages 9 and 10. Thank you. I'll review that.
No, not yet. My only other thing with the verdict form, Judge, that I thought about overnight as well, I would prefer for it to say guilty of the, like, for example, count 1, guilty of the lesser included voluntary manslaughter or guilty of the lesser included involuntary manslaughter. I did find a case, it was Flood v. State, that is 311 Georgia 800. It's a 2021 case, and the verdict form is what was being talked about there as well. And they also did, we the jury find the defendant guilty of the lesser included offense of voluntary manslaughter. We the jury find the defendant guilty of malice murder. And the reason why the state would be requesting that is simply just so as to not confuse the jury. I think the way that it looks right now, it looks like she's charged as to count 1 with all 3 things, and they basically get to pick one. And
Your Honor, I think I can.
Go ahead.
We have no objection to that change.
okay.
On which counts, please?
All of them. So count 1, 2, 3, anyone where there's a lesser included, which is counts 1, 2, 3, 4, 5, and that's it, 1 through 5. Right.
Okay, we'll work on that.
And that's it as far as the state for the jury verdict form, Judge.
Okay, thank you.
What about those first sentences? In the one.
Would y'all like time to digest version 3 in its totality? Or do you just want to start going?
I think we can, what did you say?
We can do this.
I think we're fine to just start going, Judge.
Happy to, Your Honor.
Okay. Page 1, I can't imagine there's any issue.
No, Your Honor.
No, Your Honor.
Page 2, no issue.
Nope.
Page 3, no issue. Page 4, no issue. Page 5, again, this is version 3, V3. No issue. Page 6, no issue. Page 7, no issue. Page 8, restating prior objections from the defense.
That's, no new issue, Your Honor, but
Yep.
same issues from yesterday.
Can I see V2? I went with the shorter causation issue versus the proximate cause. I apologize. Let's back up to page 4. It's a minor question or minor issue. Statement that the defendant allegedly made, parentheses, while in custody, close parentheses, has been offered. That's the way I intend to read it.
I would ask that parentheses be taken out. Your Honor's already made a ruling that the defendant was not in custody when she made that statement. And so I don't think we should tell the jury that she was in custody, because there's already been a prior ruling that it was not a custodial statement in the Jackson-Deno hearing.
I wasn't going to say anything, Your Honor, but I can't disagree. The fact of custody is a question for the court. Voluntariness, however, remains a question for the jury.
Thank you.
We note, however, that the circumstances of the statement would be relevant, so where they are, what she was doing, what's going on. So that's, the jury can consider that. But the assertion of its custodialness is a question for the court, that the court has resolved, at least that the court has resolved, and we may or may not take up later.
Noted. So that'll be removed. Thank you. That's off page 4. Version 2 was page 7. The proximate cause has been removed in favor of version 3. And I apologize. Now on page 8 of, nope, is that right? Confusing myself. I apologize. The date, not a material allegation, that was without issue, I believe. That's been removed.
That's fine, Judge.
Yeah.
as indicated, page 8 of the newest version, the issues noted on felony murder. Obviously, I have what the state brought up. I've highlighted that in purple as to 21041 and 21044.
And I was just looking at that, Judge. So I was trying to figure out a less confusing way to word it. I was looking at Long v. State, which is a 2026 Georgia Supreme Court case. And the way that the court worded it, I mean, obviously this wasn't like in a jury charge, but just the way that the law worded it was that when a jury renders a verdict for voluntary manslaughter, it cannot also find felony murder. I'm wondering if maybe we could try and word it similar to the way that the court worded it in this opinion by listing out, for example, if you find that the defendant is guilty of voluntary manslaughter as to count 1, the defendant cannot be guilty of felony murder as to counts 2 and 3, and then do the same thing if you find that the defendant is guilty of voluntary manslaughter for count 2, you cannot find, and kind of like do it like that. I don't know how the defense feels about that. I'm just trying to make it make a little bit more sense.
I support that.
Yeah.
Put on
Is that
the verdict
okay?
form? We'll put on the verdict form?
No, I mean, I don't think it should go in the verdict form. I think that it makes more sense to go in the jury charges, and I think probably both of us will be explaining that in our close anyway, but I just wanted it to be a little bit more concise. And so maybe just saying if the jury renders a verdict of voluntary manslaughter as to count 1, the jury cannot render a verdict of felony murder as to counts 2 and 3. Huh?
Is it also true?
No, we're talking about this.
I think,
They added this sentence.
I don't,
I mean, that's a proper statement of the law.
I was saying, Your Honor, I don't disagree with Ms. Bennett's statement in spirit, though I think it would be true if the jury, in an attempt to head off the inconsistent verdict, the possible inconsistent verdict problem, it would be true that if the jury found voluntary for any murder offense where it's a viable charge, that it would foreclose, that affirmative finding of provocation would foreclose a murder verdict on any of the other counts. I think it'd be true if the jury finds the defendant guilty of voluntary manslaughter on counts 1, 2, or 3, then it may not return a verdict of murder on counts 1, 2, or 3. So I think that's accurate. I just want to make sure that it's covered in all directions, not simply count 1.
No, I was saying list out each count, so then do for count 2, if the jury find, well, and we're objecting to voluntary being given for count 3, so really, from the state's position, I'm just talking about counts 1 and 2. So for count 1, if the jury returns a verdict as to voluntary manslaughter, the jury cannot return a verdict for felony murder for count 2. And then for count 2, if the jury returns a verdict for voluntary manslaughter, the jury cannot return a verdict of malice murder as to count 1. Like that, like going through and listing out each count, like defense says, from all sides, so that it's, to me, that feels less confusing. I don't know if Your Honor finds that more confusing. I don't know.
Submit you can do it if you want to file it, that's fine. All I care about is email your proposed language to everybody,
Yes, Your Honor.
including Mr. Preston, including me.
Yes, Your Honor. Yeah.
And I'll say, and I'm not trying to be an ogre here, but within 2 hours of our concluding business today, because you'll need some final version tomorrow morning.
Yes, Your Honor.
Okay, that's it on that topic.
That was it, sorry. Yes, yes, Judge.
All right, may I make a suggestion as to
Please.
21040 on page 9? That 21040 is an instruction that the Superior Court Judges Council has devised to try to circumvent the problem described in EDGE, that the sequential charging problem. I would suggest, not insist, but suggest that what's the second line in considering the malice and felony murder charges in counts 1, 2, and 3, it says you must decide. I think it is clearer to the jury to say you must first decide, because if they first decide it, then they would go on to the elements. But if not, the charge has been upheld as a proper statement of law as it is, and it's not necessary to do that, but I do think it's clearer, so I would suggest it to the court.
I like that addition.
Well, then object. I wasn't listening. I'm working on this.
We like it the way it is without the word first.
Understood. I'm going to include the defense suggestion as to the word first, please. It's on 21040. All right, moving on to page 10. I've highlighted in purple 21044. Pursuant to prior discussion.
I think that was the state's same concern with the introductory language, the may not be guilty of, but still be guilty of. And I included the language in the hope that we could be clear as to what things related to. I thought it was going to be helpful in guiding the jury through its decisional process. I'm happy to entertain other suggestions. But I also think that this is different from the voluntary issue because of the structural relationship between involuntary and the greater charges. I mean, no. So we like it the way it is, but I'm happy to. I'm not going to have heartburn if we want to tinker with it.
Okay. If anyone's got any suggestions, email them. 22021. I don't think there's any issue on that.
No new issue, Your Honor.
Yes, fair point. Defense wanted 22022. That has not been removed. Oh, sorry. I misspoke. Thank you, Mr. Preston. So as you will note, and I apologize for assigning, 22023 is gone, 22022 remains.
We'll lodge the formal objection at the statutory time.
Thank you.
This top part? That's what we've been talking about. I just proposed to just fix it. I mean, I think we need to explain it to you.
26820, obviously separate and distinct from defendant's issue at close of rebuttal.
It's the statutory language, we have no objection to that. And then we requested the line at the top of page 11, so.
Okay, thank you. 22310, I don't think there's any change on that.
Judd, I'm sorry.
Yep.
To 26820, we would just request the pattern charge. We would object to any additions to the pattern. So they can argue all day without authority. We've already established that, but it's not in the pattern for a reason, and I don't believe that Your Honor should instruct on it. I think that it's something that they can argue as far as why she's not guilty beyond a reasonable doubt, but we would request the pattern be given.
I'll look at it again.
Yes, Your
I
Honor.
understand the state's position. Assume it's the way it is right now. $240.30. Anything on that, especially related to number 3?
No, Your Honor.
Not from us, Your Honor. It was our suggestion.
I think the next page is without any dispute. Aggravated sodomy, you'll note, and I did take out the rape. I'll hear from the defense, or you can save it for later.
No new argument, Your Honor, but we'll lodge our objection at the statutory time.
Reasonable beliefs, no duty to retreat, threats justifying homicide, excessive force, revenge,
Back to page 12, the justification, if we could take out rape in that as well. Aggravated assault by strangulation, aggravated sodomy, rape, and malice murder are forcible felonies.
good catch.
We'll lodge our objection at the appropriate time.
Reasonable beliefs. It doesn't have any language in there about the defendant's unique circumstances, which is in our better person's charge. Right. We didn't have a complaint about it before because we had set a charge.
Okay.
Yeah, we're. So, actually, Your Honor, I think we,
I'm sorry, hold on 1 second.
apologize.
Did you do that right now?
I did.
Wow. The record reflects you didn't need 2 hours.
I have an hour-long drive after this. I figured it was better to do it now than later.
Everyone.
I sent it to you as well.
Apparently, everyone received an email. We'll have to do that right this second. We can. I mean, I don't have a problem with it. Let's get through here and then retrace.
So, Your Honor, I think on page 13, 31012, We had asked, and this is sort of related to, I think, the alleged violence charge on page 14. We had asked, I saw the court has dropped PTSD from the instruction. It's what it appears, unless I'm missing something.
I do not believe you're missing.
All right, but if that's the case, either one charge or the other, one will lodge the objection about PTSD at the appropriate time, but one charge or the other should reflect that it's a reasonable person in the defendant's circumstances, which was, we had no objection to 310.12 yesterday because our proposed charge included the defendant's circumstances. Now it appears nowhere in the instructions.
Okay. Fair point. So what modification are you requesting?
I'm going to have to tinker with the language, but basically the defense must, the belief must be reasonable for a person into the defendant's circumstances with the defendant's history, experiences, et cetera, because that's what the SJA language is there. The original language is in our supplement. Hold on.
Is this the pattern?
60s.
So, 312.
Yeah, so in our supplements, request number 67, in sort of the middle of the paragraph on the top of page 5, the standards whether the circumstances were such that they would excite the fears of a reasonable person possessing the same or similar psychological and physical characteristics and history of abuse as the defendant, and faced with the same circumstances surrounding the defendant at the time the defendant used force. So
Go ahead.
No, I understand it's not part of the pattern. It was part of, as we noted yesterday, the battered person syndrome pattern, which has itself been obviated, but the issue, the from the defendant's perspective, reasonable person under those circumstances,
Come on up.
is still part of the
I
law.
was just thinking in my mind that we need to change that drum, so good work. Thank you. Or cartridge or whatever it is. Thank you. Go ahead.
That was our point, Your Honor, that it is not simply a reasonable person, but when we're bringing in the history of past abuse, then it is a reasonable person in the defendant's circumstances with their history, the history of abuse. So we'd ask that that be included.
I'll look at that. Thank you. Go ahead.
We would object, this is pattern 310.12, is the pattern for reasonable beliefs explaining what defense has done, is taken the pattern for reasonable belief and then added a different unrelated pattern charge to the reasonable belief. And we would ask that Your Honor give the reasonable belief explained as it's given in the pattern and not to the defense is picking and choosing sentences from the battered person syndrome charge and putting it into the reasonable belief explained charge. And again, battered person syndrome is not relevant in this case. And I believe it would be improper for us to basically be combining pattern charges. And we would just ask that the pattern be given. They can argue whatever they want in close. But as far as instructions that fit the facts of the case, battered person syndrome was never mentioned and does not fit the facts as to this case. And so we would ask Your Honor, give the reasonable belief explained as pattern has it.
Your Honor, I'm not going to rehash the same things I said yesterday about the fact that we didn't ask for the words battered person syndrome, but the evidentiary framework is still, the framework of relevancy is still pertinent. But I would also note from the preface to the Georgia Suggested Pattern Jury Instructions, Volume 2, about halfway down, I guess the third paragraph in, these instructions are submitted as suggestions only. Your Honor, the instructions are not the law. The question is to tailor the instructions to the law as it applies to the case. I know Ms. Bennett does not believe that these issues apply, but they absolutely do. The premise needs to be included somewhere. If it is not in that instruction, the jury needs to be told that to take into account the defendant's circumstances, a reasonable person in the defendant's circumstances with a history of abuse that she has suffered. And also we would note, we would object to the absence of PTSD from that list.
Understood. Thank you. I'll look at that. Thank you. All right, back to, I believe, page 14. Is that where we are? 14?
Yes, Your Honor.
Thank you. Other than the PTSD parts, anything else we need to talk about?
Just the same objection with the court's elision of the reference to rape. And the definition of forcible felony at the top of page 14.
Meaning that rape's not included in there and you
Yeah.
want it. Got it.
Yes.
Sorry. Thank you. Got it. What else on 14?
Nothing from the state judge?
Nothing in addition to what's already been stated, I think.
And I can't imagine anyone has anything on 15.
No, Your Honor.
We have 1 second with Mr. Willis.
Yeah, more than that.
Your Honor, we think that the 3.60.10 really is no pertinence to the case at this point. No one's alleged that there's been involuntary, sorry.
Is she okay?
Let's find out.
Everyone's good? Okay, I'm sorry. That's fine. I didn't know. All right, go ahead. What was your issue? I'm sorry.
So I don't think that, I think that 3.60.10 is. Page 14, bottom of page 14.
Thank you.
Certainly. It's unnecessary. There's been no assertion or really discussion of intoxication in a way that undermines anybody's mens rea or the
So take it
capacity
out?
form. I think it should be out.
I would ask it stay in. I elicited testimony on cross of the expert about all the medications that she was taking and the side effects that can be caused by taking all those medications with alcohol. And so I think that it is relevant to make sure the jury understands that taking all those medications with alcohol, if it causes negative side effects, it's not a defense. And so I think that it is still relevant to the facts of the case.
Okay. I'll look at that also. Thank you. What else?
Stand on our objection.
All right. Anything else?
No, Judge, and like I said, I emailed the suggestion for the voluntary and involuntary charges.
All right. Mr. Preston, I will work a little.
Yeah. You want me to email it to you?
I've got it.
We'll work a little bit more on this.
Thanks.
Y'all got a copy?
We do now, Your Honor. Or I have it in email, but
And it's like
this is lighter than my iPad.
Yeah, and I objected to 3. But obviously, if the judge gives 3, then it would just be the same thing, but adding in more counts. If you find the defendant acted in such provocation of count 3, you would not be authorized for counts 1 and 2, and then same with, you know what I mean?
Yep.
Okay. So basically, just like a third paragraph, if Your Honor gives the voluntary for count 3.
if the court's comfortable with it, so are we.
Okay. We'll head in that direction.
All right. Your Honor, may I think I said yesterday, or asked if I could defer some specific ruling, up or down rulings on specific requests.
Would you like to do that now?
I would, if Your Honor would indulge me. At least let me list.
I will indulge you. How long do you think it might take?
I think I can do it in less than 5 minutes. Because I think I want to go through and list the numbers, and
What are we doing?
I want some
up or down ruling on
specific
request to charge.
Okay.
Just for purposes of the record.
Yeah.
All right. So I'm working backwards, Your Honor. Our request number 67, which was in our supplemental, and that was our request for an instruction, or one of our alternative requests for instructions regarding the PTSD, family violence, the SJA evidence. For the same reason, we'd ask for an up or down on 37, which was their first stab at that instruction.
I'm sorry, you say 3-7 or 6-7?
Both.
Okay, so let's go one at a time. I apologize. So on 6-7, you're asking for up or down. So for the record, that's denied on 6-7.
And 37 dealt with the same subject matter. We had two attempts.
And I apologize. 3-7, is that in your
That's in the initial,
request? Yes.
Our initial request, page 38.
Yes, thank you.
And similar in proposal, it deals with the same subject matter, worded a little differently.
So you're requesting a ruling on 3-7. Your request is denied, or your request to charge is denied.
Understood.
On 6-7 and 3-7.
All right. And, Your Honor, I would also ask for specific rulings. Well, let me get down to it. I'll try and our definition of felony murder. I know what the court has said, but I think approximate cause. I think our specific requests, 39 and 40, which deal with the elements of felony murder and the Apprendi issue that I've raised before.
I apologize. Is it, you said request number 39?
Request number 30, they are on pages 41 and 42 of our initial submission. They deal with the Apprendi issue that I raised for the court before.
39, request to charge is denied. 40, request to charge is denied.
And then similar request with respect to, or similar, I swear the next time I do this, I'm going to index them for myself. I would ask for similar, I would ask for the courts to decide. I know the court has included the definition without authority. We had some additional requests regarding without the meaning of authority under these circumstances. 48 in specifically.
I apologize. Charge number 48?
Request 48, page 50.
Thank you. Understood. Request to charge 48 is denied.
And not to skip around too much, the court has really, I guess, already ruled on our request number 47 by excluding it.
Request number 47.
Well, I guess page 47, request 45, but the court's already ruled on that by excluding it. We've noted. And I think that was all that I wanted to make sure of for the record.
Since I'm here, request 45 is denied.
All right. Thank you for your time, Your Honor.
No, thank you for yours. Anything else we need to talk about on jury charge issues?
Not from the seat, Judge.
Did y'all have something?
With respect to the ones that you're still working on, is the court Is the court intending to send an email or something tonight, so that you know what the is moving to tomorrow?
Very likely, the final version will be emailed to y'all within a reasonable time of conclusion.
And as you said yesterday, the state typically will open and conclude. I always like to ask if that's their intention, because otherwise I have to set up first. So are you opening and concluding? Okay. I may try to get, I'll just contact Kenny from IT in case we have an issue on the switch. But I'll quote that. I just want you to know that's the only thing I have concern about. Thank you.
Let me get my stuff organized. All right, I appreciate everyone. Y'all done an excellent job up to this point. Sheriff's Department, I have noticed that after lunch, we got to not full capacity, but pretty robust attendance. And typically, people tend to come in more for closing arguments and verdicts, et cetera. So I want to make sure we're all on the same page. Row 1 is typically for court personnel and lawyers, et cetera. Row 2 is labeled that as well. Is there, and I'm not questioning it, is there a safety and security issue as it relates to 2? Okay, so 2 will remain court personnel and lawyers. Okay, so FYI, you know, I don't want to start excluding people, but there is a live stream, and I'm not saying we're at that point, but I'm going to ask my bailiffs and maybe the Sheriff's Department, if it gets pretty crowded and lawyers start piling in the back, maybe ask them to come to the front. And I understand that sometimes they want to leave, I get all that, but if they hang out in the back, that could be something that could otherwise be used for the public that they wouldn't otherwise have. So if they could gravitate more towards the front, and I'll ask the bailiff to do that as well. The door, so I would imagine at some point, and again, I'm not a juror, I'd imagine at some point they may want to look at the door. So I would imagine that would be bringing them all out here to do that. We could put it in the jury room.
Yeah, I think we should put it back in the jury room with the judge.
It was tendered, so
I understand it was tendered. I mean, I had a very large truck bumper tendered once too, and the court reporter begged me to take a picture of it and not make her keep it for the rest of her life. So yes, it has been tendered. I just want to make sure we're all on the same page that's why I'm bringing it now versus.
We can make sure that we have the proper tools to wheel it back into the room with the jury, but we would ask that the door go back into the deliberation with the jury.
But we'll take a picture of it so the court reporter doesn't have to
take a picture of it for court reporter.
So that was, yeah.
Purposes.
So yes, so the good news was the bumper was on a civil case, and I'll be honest, I'm not an expert on. I think this goes back to the Sheriff's Department. I don't know. I don't think the court reporter is going to keep a Beretta and a Glock, et cetera, in all seriousness. We'll let the court reporters debate all that. But just from what do we envision? It's make them ask for it. I tell them, hey, if you want the door, ask for it. We just go ahead and ship it back. It's not a big room, so that's why I'm asking.
So go ahead and ship it back with them, with all the other
I'd send it
evidence.
back, Judge, respectfully.
Okay.
Unless they ask them to have it removed, which we don't have a problem with.
And unless they ask for it to be removed, I say when we give them all the rest of the evidence, we just ship it back with them as well. They can lean it up against a wall, they can put it on the floor.
Okay, there's obviously a minor to moderate safety and security issue with it tipping over. It doesn't appear, I've not touched it. It doesn't appear to be a super heavy door, but obviously y'all have had a makeshift base for it. So taking that in consideration, I know on some level, I mean, people have been using gloves. I mean, do we direct the jurors if you're going to touch it, use gloves?
Yeah, we'll make sure that they have gloves, Judge. I'm gonna leave it there, thank you. Yeah, we'll make sure that they, use gloves if they're gonna touch any of the.
So I'll give them sort of a overview of that issue. Any other practicality things we need to tell them?
Not that I can think of at this moment, Judge.
As a- I'll very likely also tell them that, you know, they're going to have all the evidence, but if they wanted to review any audio or video, they need to come back into the courtroom to do so, which is my standard operating procedure. I'm not the only judge in Georgia, so maybe somebody does it different, but that's the way I've done it. Any other practical pointers that we need to consider?
No, Your Honor.
Door, evidence, nothing?
I think so.
Gloves. Okay.
Thank you.
See y'all tomorrow. Thank you.